Yes.
Adjournment request, if any, from item number 1 to 7. From item number 8 to 17.
No, just hold on, Mr.
My
Lord.
Lord, Lordship
Sorry.
indulgence, I would like to mention item number 6.
Item number 6 is what?
This is a contempt matter. My Lord, my affidavit is ready, but it could not be vetted yet.
You appear for respond number
Respond
1.
number 1, my.
And have you informed the petitioner?
Yes, sir, petition. He is there.
Take them. Mr. S. Datta, learned senior advocate, appearing for respond number 1, seeks some time to file his affidavit as desired by this court on an earlier occasion. The affidavit is ready. The affidavit is ready and shall be filed in a couple of days
Right.
in the registry. So let this matter come up for consideration. Sometimes in February, the
Up to
construction.
your Lordship's convenience.
February.
9th February.
Much obliged.
May I please, your Lordship? My Lord, I am paying for listing a matter. on-
Just a minute, adjournments
Lordship, I'm sorry, Lordship.
we'll deal with first. Yeah.
Item number 8 to 17, adjournment request.
Yeah.
Item number 18 to 30. No. Any other request?
Yes, now you can make.
May I please, your Lordship? Lordship, I'm paying for listing a merit appeal, Lordship, on next week, the Lordship, the 16th of December, Lordship. Urgent in, matter is urgent in nature because settlement of market. Lordship, please to pass an order for election time on next Tuesday, Lordship.
What happened? Settlement of market, was it tendered?
$10, Lordship.
Then what happened?
And my read petition was dismissed, Lordship.
No, you were disqualified.
Disqualified.
On what
because
ground?
Only Bakijai certificate not enclosed.
What certificate?
Bakijai clearance
Bakijai
certificate.
not.
Only on that ground. That defect can be cured, Lordship. The judgment is also
Curable defect is all right, but then
My-
what is the London Single just said?
on that ground, Lordship dismissed, my Lord. Since I have not annexed the document clearance certificate.
Anyway, we'll look at it on Tuesday.
Lordship, obliged, my
Monday we have put many matters.
Lordship.
16.
May I please, Your Lordship?
Yes.
I beg to mention for listing of a writ appeal, my lord. Order was passed by the maintenance tribunal
Mhm.
constituted under Maintenance of Senior Citizen and Parents Act, my lord.
Yes.
Eviction order was passed, single judge has upheld, my lord.
Hmm.
I may be evicted anytime, my lord. So
Wednesday.
if possible, my lord, Monday.
No, Wednesday.
17.
Lordship, I am beg to mention a writ appeal for listing on Wednesday, Your Lordship, regarding to APDCL. Honorable Single Judge has given the right to the appellate tribunal to review the order,
Hmm.
wherein there is no right as such in the Electricity Act, Your Lordship. So,
No, that's all right. Review
and
is
also
always-
there's a like
Review is always a creature of statute, but then under the orders of this court, passed under Article 226, why do we further review it in the garb of an appeal?
no,
I don't think there is any urgency. January.
Lordship, on Friday they have given.
Doesn't matter. You say that you have filed you depend upon the wisdom of the board or the authority. You say that you have challenged it. Not
Lordship, give us an opportunity, we can satisfy Your Lordship that there is enough
Or-
ground.
see it in January.
7th of January.
January.
If I may, item number 64 in supplementary list, the arguing council is on sick leave.
64. I don't
Sup-
think there are supplementary list. Where is it?
Yes.
Those are for orders.
Okay.
So we have already heard everything.
No, that-
It was 64.
Up to 63 is the scale.
64, what do you want?
The arguing council is on sick leave.
Hmm.
So let it come anytime after vacations.
Now you frame your sentence properly. Let it come is not something that is, you leave it for us. Let it come. You make a request that it may be posted.
Yes,
Now this is just an advisory to you.
I apologize, Your Lordship.
Don't apologize. You rectify. We are not offended by this, but you might get a rebuff from another bench. No, let it come on that date. That's very pompous, right? As prayed for on behalf of the petitioner, let this matter come up for cut. We say let this matter come up for, and we say it through the registry. You don't tell us.
Lordship,
Let-
I'm appearing for respondent number 1 and 2.
Any objection?
No, Lordship.
Let this at the request of learned counsel for the petitioner, and agreed to by the council for the respondent, let this matter come up for consideration sometimes in February. Yes,
2nd of February. Daily list for orders, item 1.
hearing.
One.
Walk away. You just know. This is the same thing. Hmm? No, okay. Here, condemnation. Yes, coming for the first time.
Lordship, there is a delay application for condemnation of delay, my lords. Delay is 278 days.
Service report.
My lord, it was last listed on 21/10.
Appears for the health department.
Last time, my lord, Mr. Chalia was there.
Some council of the government should be here, no?
Mr. Gogoi was there. B. Gogoi was there. He was sitting with me.
No, whatever, but if nobody is there, she should be here. She keeps her head buried all the time so that I don't look at her. If a lawyer for the state is not there, you please
I will.
pitch in. Now, nobody is appearing. It's a delay of how many days?
278 days, man.
278 days. We are condoning it.
My lords.
Delay condoned, heard both sides.
Obligation, my lordship.
I'll inform the state
Appeal to be processed.
standing.
Inform the council.
I will.
18 February. Item number 2.
In item 2 and 3, the order is under challenge before the honorable apex court.
Still pending.
It is still pending. On 13th of January, it is fixed and stays there.
Mr. Nath, Land Council for the respondent submits that the SLP in the connected matter is pending consideration before the Supreme Court. Let this matter come up for consideration in March, date in March, 2 and 3 both.
23rd March.
Eviction without notice, the YAP order.
Item 4 and 5.
Yes, Mr. Nath.
Malad, in item number 5, I am appearing.
Hmm.
I prefer some time Malad, to file an affidavit in that.
And about 4?
Item number 4, Malad, I have no notice.
No.
The respondent is same, Malad, I can talk to him, Malad.
Not steps taken, but he is there, no? You accept notice on behalf of respondent number 4.
It's a contempt matter. Lordship.
Doesn't matter.
Lordship.
Mr. Nath, learned advocate for the proposed contemners, submits that reply affidavit shall be filed by the next date. Re-notify March.
16 March.
Obliged.
Item number 7.
Service is awaited, but only 11 days. We would have done it, but for the technicality.
Only just
Awaiting the
technicalities.
service of notice on respond number 11, the matter is adjourned to first week January. After that, we will condone it.
Lordship. Obliged.
95 date.
7th January. Item 8.
May I please, your lordship? Lordship, today I have filed affidavit in opposition against the delay condemnation filed by the petitioner, lordship. Kindly matter be taken up after.
This is an
petition,
application
lordship,
seeking.
along with the record.
All right, this is an application seeking condonation of delay of 595 days in preferring the appeal. Stop the land council for the respondent has filed his objection petition, which is yet not on record. Let this matter come up for consideration on February.
Lordship, first week of, January.
February.
Lordship, petitioner and. in the
Where is the
detail,
problem?
lordship.
You have succeeded. There is no stay. The appeal is yet to come.
No, lordship, and now the.
All right,
respondent
January.
is, face some various
All
difficulties,
right,
lordship, financial as well as health.
We have
lordship.
followed it, January.
Kindly, it may be on January, lordship.
January
21 January.
Hear what the court says. January, we have said that.
Lordship. Obliged.
21st January. Item number 9.
Yeah, my lord, in respect of item.
You appear for respond number 9?
No, my lord, I am, oh, yes, no, 1, 2, 5, 6, 7, 8, 10, 10, my lord. During the course of the day, I am going to file my lord objection.
All right, there is an application seeking condonation of delay of 187 days in preferring the appeal. The the Land Council appearing for response number 1 to 8 and 10 to 13.
The 10, 8 and 10 only.
You are appearing for only 8 to 8.
Yes, sir. 1, 2, 5, 6, 7, 8 and 10 only.
One to 8 and 1 to 8 and 10 submits that he shall file his objection petition by the next date. Stop. There is no report regarding service of notice on respond number 11.
11, I have to file a substitution. There is a expired.
You have to file a
Yes, ma'am.
substitution petition.
Yeah. Next week I'll.
Mr. Khatni, a learned advocate for the applicant, has submitted that respond number 11 is dead, and therefore he'll file a substitution application. He'll file a substitution application by the set date. After that, all are served.
Yes, ma'am. After that, all.
9.
Still awaited. In respect of 9, my lord.
Awaiting these
9 to the expert.
service of notice, awaiting the report regarding service
Sure.
of notice.
Yeah.
Response number 9 and respond number 9. The matter is adjourned to February.
9 is expired, my lord.
11 expired.
11.
6
And during
February.
the course
He
of the.
said so.
Yes, ma'am.
I think, is my voice not reaching you people?
I'm sorry for that.
No. We would have it corrected if I'm not audible. There's something wrong with the system.
We'll file objection today itself, ma'am.
6
We'll
February.
give you time till the next day. Do it today, do it tomorrow, it doesn't matter.
Supplementary list, item 31 to 62.
Aliana,
Is Mr. Advocate General here?
he's here. Can you take it up after September? Not.
I'm being. Item 63.
Yes.
We have filed a leave for appeal, my lord. Notice has to go. There is a condemnation petition. The petitioner was the appellant was the most affected party. They was not heard.
There's an application seeking. So you've filed an application for leave, not for condemnation.
Leave also because delay is there, my lord, the matter of precaution are taking. Ma'am.
So that was not required. There's an application, there's an application seeking condemnation delay of how many days?
449 days.
449 days in preferring the appeal. Stop. Let notice be issued to response numbers.
All.
Oh, he's here.
He is here, then AFC is there, my lord, Assam Financial Corporation notice has to go. Respondent number 2. 2, 3 and 4, my
What
lord.
is your name?
S. Hockner, Mr. S.
S. So and so, learned advocate has appeared on behalf of respondent number 1. He seeks some time to put in his objection petition. Let that be done by the next date. Let notice also be issued to respondent number 2 / so and so.
2 to 5, my lord.
2 to 5 on steps being taken by the applicant / colon within a period of 2 weeks, both modes, returnable March.
My lord, if your lordship permits, I would like to take Dusty service. Dusty.
The Dusty service as well. On
Right.
respondent number.
2nd of March.
Yes.
2, 3. 2nd of March. Daily list, item 10 for admission.
No, in the other case, respondent number 2 to 5, my friend will take.
You're there. Why do you have to come so late? So and so has appeared on behalf, accepts notice on behalf of respondents number 2 to 5. No. Objection petition on their behalf also shall be filed by the next day. Re-notify himself. Yes.
2nd March. Item 10.
Lordship is.
Yes.
First of all, Lordships, I'd like to give my apologies. There was one important, in fact, information that I could not put. It slipped out of my mind. It is my
Doesn't matter.
responsibility.
Tell us what is the.
Section 17 application, we filed it, but it could not be moved. because-
That's a very, in fact,
Yes.
petition could have been dismissed for that.
that is the reason I'm first making an apology. This is my mistake. It was overlooked for some reason, and therefore I'm telling your lordship straight. It is my mistake. It was filed, not moved, because the benches were not available. Presiding officer was not there.
Now,
But we should have mentioned it, my lord. This is completely my mistake.
doesn't matter.
Yes, my lord.
Doesn't matter. Now that it's not a deliberate omission.
That I
When you-
have to
when you
inform
mention
you.
it- When you mention it at the first instance, it's not deliberate. All
I'm
right.
extremely grateful.
So now therefore you move the application under section 17.
Yes, my lord.
You move.
Yes,
You
my,
move.
no, we've not moved, only filed.
Now you move the application.
Yes, now I moved the application, my lord.
So
Yes, my lord.
therefore-
I
this-
understand. No, I only wanted to tell your lordship, this is my
No, but
problem.
then,
Would your lordship be kind enough to,
But why do we entertain this petition? That's the
it's more of a, my lord, more of a mercy petition. Today, my problem is, this is my residential house. And after the physical notice was issued to me, my lord, they called me to the bank. I went to the bank and I made a deposit of 4,30,000 rupees with the intention that will be regularized. I have annexed that also.
That's all right. We quite appreciate that. But then in matters, in these matters, the Supreme Court says that we should keep our hands off.
I am absolutely aware of this, my
Starting
lord.
from Satyavati Tandon down to.
I agree, my lord. I
Yes,
bow
then
down
we
to that, my lord. I bow down to that. All I'm saying, my lord, is that
Any order passed by us at this moment would be suspect. Suspect in the sense of legal scrutiny.
understand.
So therefore, we tell you, who appears for the bank.
Yes, I am happy.
Now, let that application be decided. DRT petition be decided.
Yes, your lordship, a special bench is also arranged. Silchar bench will take up the urgent matter for DRT.
There is a,
In the meantime, you don't take any coercive
that's all
steps.
I'm requesting, my lord.
We are not saying so. We will give an undertaking for another 15 days. Heavens are not going to fall. You can do that.
No,
Yes,
your
we-
lordship, a special bench is there, so they can move their.
They can move the application, but in the meantime, we are asking you, don't precipitate the matters. We don't say for eternity. We say only for the first date, second date.
Extremely grateful, my lord, for that. 15, 20 days.
But,
You'll have to seek instructions.
yes, yeah.
You'll have to seek instructions from the bank.
Yes.
Now, we are disposing of this petition, but take instructions, telephonic instructions that there will be general observation that you shall not precipitate the matter till for a fortnight.
But we also did not receive the copies, Your Honor.
Give him a copy.
I have. already
Very
served, my lord.
difficult.
No, man, it's already been served.
Give a copy. Give a copy.
We've
to him.
normally-
We'll hear you tomorrow.
Yes, sir.
We will hear you tomorrow. Take instructions. Tomorrow is on Monday.
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 Just the instruction. We are not entertaining this petition for any reason. But you see, your manager tells him to deposit money. He deposits the money. He is asked to regularize his account. You don't regularize the account. What is the amount left now
Yeah.
to be paid? Very
I will
meager.
take the instruction.
I mean, that's not the way. That's not the way you deal with it. SARFAESI, all right, DRT, DRAT, and everything, all right. But then the loan has not gone bad practically.
10-year.
Normally, Your Lordship, once it was become NPA, then and after 13 to notice, they has to pay the full amount. It is the discretion of the.
You only accepted that amount. No. So are we asking that no?
I
this
will take that
proceeding. Don't initiate the proceeding. Do we say that?
Yeah.
This was our first refrain. We can't pass an order like that. But then we are only asking you, be logical, be just.
I'll take the instruction.
You don't have always to take that aggressive stand. Huh? Ligiev, let a copy of the writ petition be handed over to the council representing the bank, creditor/bank. Let this matter come up for consideration on, give a date on Monday.
I'm extremely
15.
grateful for that. question.
Item 11,
Yeah, please, your lordship.
Yes,
Yes, your lordship, this PIL is filed by the petitioner society regarding the lapses in the railway for safety, derailment and all this.
these are, wishful thinking, not even wishful thinking. You want the court to monitor what the railway should do.
We are not, we were the court.
Exactly. That is what you're asking. We don't think there's a specific judgment on this, which says that these matters, especially,
Yes, sir.
let me just see. This is Uttaranchal versus Chaupal or something. I think so. In fact, the courts came down heavily. Railway safety protocols and all that. We are not issuing notice to Mr. Chaudhary.
Yes, your lordship.
What's your name?
M.R. Sudhir.
The present public interest litigation has been filed alleging that the railways have failed to improve punctuality, safety standards, amenities, and service quality. It has also been alleged that the advanced Kavach automatic train protection system has not been fully rolled out, and that the railways are prioritizing expansion over maintenance, thereby exposing vulnerable commuters to risk of accidents and derailments. At the outset, we note that the petition is bereft of any concrete material particulars or data, except for broad statements and general assertions. The writ petition does not refer to any specific incident, identified safety lapse, particular to any stretch of track, or any statutory violation that would justify exercise of this court's extraordinary jurisdiction. A public interest litigation is a serious judicial instrument which cannot be founded on sweeping allegations, perceived administrative insufficiencies, or general grievance about systemic functioning. The courts must guard against vague and ambitious petitions, must guard against vague and omnibus petitions filed without adequate research or factual foundation. Next. Policy matters relating to railway safety protocols, technical deployment of the Kavach system, allocation of resources, prioritization of expansion versus maintenance, and strategic rollout plans lie squarely within the domain of specialized technical authorities. Courts do not substitute their wisdom for that of competent experts unless there is demonstrable arbitrariness, illegality, malafide, or inaction in the face of a specific statutory duty. In this petition, there is no averment regarding breach of any statutory rule or any material to show that the railways have ignored binding directions for improvement of service or to supervise day-to-day administration. Entertaining such petitions would convert this thought into a kind of super regulator of technical policy, something which has expressly been cautioned against in many cases of the Supreme Court. General governance of a department is not to be carried out through judicial orders on vague demands. On going through the petition, we find that the grievances are more in the nature of general policy suggestions and not an enforceable legal right. The railways, being a public sector undertaking, are nevertheless expected to continue upgrading safety systems, modernizing infrastructure, and deploying protection technology as per expert assessment and budgetary prioritization. However, such matters cannot be directed on the basis of an indeterminate known evidentiary PIL. For all these reasons, we dismiss this petition with liberty to the petitioner to pursue already filed representations, or if not filed, fresh representations before the competent authorities, if so advised, with specific instances, documentary materials, and identifiable legal violations. No order as to costs.
Deeply obliged.
इसमें उत्तरांचल versus Bhopal. Yeah,
Timing item 31 to 62.
Yes, Mr. What we have done is, subject to what you say, because we asked you not to press this, it becomes.
Yes, I'm not pressing it.
No, we have to say something about the policy of 2014. Policy of 2015. What in this judgment we have said, because it was not dictated in your presence, therefore we are saying it. It is yet to be fully, typed. We have said that the decision of the learned single judge striking down clause 1 of the OM of 2015 is correct, for the reason that this classification cannot be made. Now, there is no guarantee that the family members of persons dying with larger service left would not resort to any fraud or misuse. And DS Nakara strictly applies now. This is a homogeneous group. The entire class is homogeneous. So what we have said is this. Now, don't get worried that you have not argued, and we have said yes to the single judge judgment. We have said that the striking down of that first part of 2015 OM is correct. Nonetheless, with the law as on date, where delay is an important part, the authorities shall look into the delay aspect, and we have quoted from the judgment which says that whether the delay is on account of non-adjudication of the application or delay on the ground of late filing of such application, it matters not. If more than 10 years have passed, everything is lost, immediacy is lost. But then we cannot just close the window on their faces for the reason that this 2017 OM, which supersedes 2015, that is not with retrospective operation. So we say that the authorities shall consider it, but keeping in mind the primary aspect of the matter that there has been a delay of more than 10 years. Don't give false hopes to the applicants and decide the matter expeditiously. The delay, and we have quoted relevant paragraph from Devvrat Tiwari, that the delay extinguishes the cause. I think it's the same thing. Because otherwise, we have not said that we have only recorded that the learned advocate general says that with this view, with this interpretation of law, as on date, the petition has become academic. We have said, but we have unless otherwise we are ready to change it.
Lordship may keep that issue open for future.
What?
That issue, whether that particular clause.
That we can't do, no. Because it doesn't matter. All these applications which have been relegated.
Suppose tomorrow we change the policy again.
You will have to read it. We have said, just a minute, let us read. This is what happens when I always. We have also quoted from State of Uttaranchal and another versus Sip Charan Singh Bhandari, which says that even if court or tribunal directs for consideration of representation relating to a stale claim or debt grievance, it does not give rise to a fresh cause of action. The dead cause of action cannot arise like a phoenix. Similarly, a mere submission of a representation to the competent authority does not arrest time. And then after having said that, we have examined the aspect of constitutionality, and we found that there was no reference of this fraud or other things, or for that matter, 3 years gap in the draft note to the cabinet decision, number one. Number two, you say it is akin to the DOPT regulations of 2013, which also is for with respect to other persons, that is medical.
Medical
grounds.
incapacitation.
Therefore, the rationale is lacking. So we have
Like
said,
here, in this clause also, there are three situations, Lordship. One is died in harness, the other one is became incapacitated due to accident, and third one is missing.
Missing.
in any case,
In all these situations, there are 3 years.
that's right. But this, we have said that. We have said that this was the basis, but we have not agreed that this is constitutionally correct. We couldn't have helped it. We thought proper to close the petition. But then it was not possible. So if you want to argue, you can argue. What we have done is this. On these grounds, we find the declaration of clause 1 of OM dated so-and-so to be constitutionally invalid by the learned single judge to be wholly justified. Now, the question to be decided is whether it was appropriate for the learned single judge, even while taking cognizance of the supersession of the office memorandum dated 1/6/2015 with office memorandum dated 14/9/2017, replacing compassionate appointment with compassionate family regulation, in all writ petition, whether relegation was justified. The new policy of the state, by OM dated 17, replacing compassionate appointment with compassionate family pension scheme would be applicable from a cutoff date in the year 2017, which is not applicable in cases of respondent. The policy of the state, which was prevalent at the time of death of the employees, would only be applicable to the respondents. And in that case, there would be some justification for sustaining the relegating orders by the single judge, notwithstanding the passage of more than 10 years since the death. Though we have taken the argument of the learned Advocate General with some seriousness that the judgment of the Supreme Court in Devbrat Tiwari prohibits compassionate appointment after long passage of time, but in the present set of cases, closing the chapter for the private respondents would not be appropriate. We thus affirm the relegating order by the learned single judge. While making such application before the concerned authorities, the private respondents, we may caution, must not entertain any false hopes, and the concerned authorities shall also consider the passage of time aspect seriously while assessing the suitability of those respondents for compassionate appointment, which would be the most important factor in recommending the cases of the private respondents for compassionate appointment, which ultimately may not withstand the judicial scrutiny if such recommendation is made after a long lapse of time since the death of the deceased. I think it closes it.
Okay.
With the aforementioned observation, we close these petitions. So what we have done is that we have sustained the judgment of the single judge because constitutionally it was correct. See, you have gone through Canara Bank judgment.
I have gone.
Canara Bank, other aspects we are, that's what the other.
There are
judgments
4
say.
months were left.
No. Canara Bank talks about which policy decision would be applicable. Now, the common rule is that the policy decision which is applicable would be the policy which is prevalent at the time on the death.
Yes, Lord.
At the time of death. But there were many division bench judgments of the Supreme Court which says that no, the policy which is applicable at the time of consideration is applicable. So there was a full bench and then again there was a divergence. In Canara Bank, the Supreme Court said that, well, there is a judgment. There are 2 judgments at variance. So here the bench would use Article 142 and decide that the policy which is policy applicable would be the policy prevalent at the time of death. So therefore, for all practical purposes, the law has not been changed. So therefore, not, stopping them from going to the authorities would be inappropriate. We have said that passage of time is the main thing now.
Whether they will have to submit fresh application now after this just.
How can that be?
Or the same.
They were in the
Their
final
cases are
stage.
pending, they will decide. Here they will say.
No, in most of the cases, it was rejected in the state level.
They would bring to the notice of the authorities a copy.
Even when it was decided, most of the cases were decided in 2019. At that point of time also that immediacy clause is not there.
No, we can say that they can file fresh.
Let it be the original.
My lord, lapse of time during the litigation should not be counted.
That is a judgment.
Yes,
We can't help it.
yes.
It is, we are only, for all practical purposes, we have closed the cases so far as you are concerned. No appointment, no compassionate appointment after 10 years. We have practically closed it. But the question is that we were supposed to decide about the constitutionality of the OM, that we have decided. So what you do is, we have said that all authorities shall look into this aspect of the matter, that there has been a delay of 10 years. You have been able to tide over that travails.
That observation may be made.
We've said
Then I have no objection.
Lordship, one submission is that earlier cases in while we have challenged the 3/4/25 after passing the Bhagavatam case, Lordship. State has passed an issue impugned the Lordship.
No, there's no case.
Memorandum regarding delay. And my learned senior advocate general Lordship made a submission in paragraph 7 of that judgment, disposed of 3/4/25. That in those cases, that's regarding delay will not be questioned, Lordship.
No, how can you say that?
And one judgment.
How can he say that? How can he make?
My
a-
learned,
How can he make a
Proposal
concession which goes beyond the Supreme Court judgment? He can't.
in that case, Lordship, paragraph 7.
Whichever-
So the
If
consider
Advocate General has made that
only the
concession,
pending,
withdraw that concession.
only those pending cases, Lordship.
Sorry, sir.
Only present cases, Lordship, our submission.
The judgment in Debrat talks about present. Which case? I don't think.
And we have issued a notification also in
Lordship,
2023.
Paragraph 7. So without going
Yes, sir.
Without going further in the issue as to whether the impugned OM dated 18/9/2024 is bad in law or not, it would be proper to refer to the proposal that had been made by the learned AG Assam on an earlier date, which is to effect that all the applications for compulsory appointment in relation
Yes,
to the
okay.
cases which are pending in this court challenging the impugned OM dated 18/9/2024 shall be considered by the
That's-
concerned
that's-
authority
There is no. we
on
have
merit.
that. We have that, Mr. Kaul.
On merit, Lord.
Assuming, no, on merits, all right. But on merits, it shall be considered. But while recommending, they will keep in mind that delay is not to be
And
considered.
then after that, we have issued a SOP also for our officers where we have highlighted this concept. the
Okay,
delay.
so therefore,
We-
therefore, you don't ask for closing it down because this is your submission. We have done it because finally it will close it.
That is why yesterday I made the submission that even if its lordship sustains paragraph, that particular clause, ultimately the result will be same. That is precisely why I do not want to argue on this point. And on top of that, that policy is no more there since 2017.
So that ground does not
No.
go against them. Because you have not made it retrospective and you should not. So therefore, we can't close the window there, but them.
No, they have to get a fresh order, speaking order against the policy. That will do lot.
That is
Principle of the Bhagavatam should be applied. Michael provides. The Bhagavatam apply for.
And we have quoted with approval the observations of Supreme Court in Haryana State Electricity Board and others versus Hakim Singh, which has been relied upon by all judgments. It says that it should not be forgotten that compassionate appointment is to give succor to the family to tide over.
That is the
sudden-
main concept, lordship, that Hakim says that has been followed all throughout in all the policy, and that is why Article 14, they're just
We
slide.
have also quoted that any recommendation for appointment after a delay would amount to treating the claim of compassionate appointment as an inherent right which is not permissible.
Yes,
So I think
and it cannot go continuously.
Dealt with earlier also.
all right, we have neither allowed the application nor dismissed the appeal. We have said that we close this petition with the afford noted author.
Lordship.
So far as a successful patient died, my lord. My lord, one mitigating aspect is there, my lord.
Sir, 10 years.
But the
compassionate appointment-
doctors profited. One last line.
With all respect, my lord, one mitigating aspect, my lord, I beg to bring to the notice of your lordship. On the basis of this or court's order, my lord, there are many recommendations by the DLC, my lord.
What has happened, but it shall not happen from now.
That is there.
Now, our officers will still commit mistakes. I know that, Lordship.
Ah.
That is why we have issued a SOP now
Yeah.
to give a clear whatever is there.
It's very unfortunate, but you can't use this, a death in your family of the bread earner to make it a kind of passes into government service. And after so many years, absolutely impossible.
Absolutely, this is logical.
Absolutely not. That we are not saying it out of our own understanding. This is the way law has developed.
For last,
We have permitted you to press your applications there, but we have directed the authorities to be careful in recommending.
Yeah.
That's all. All right, yes.
highly obliged, Lordship.
Item number 12.
No, but Mr. Counsel, your application appears to be vague. You say that ADM was deputed,
Yes, your lord.
right? Commissioner of Police, you also paid him for the escort or guard.
Yes, yes, your lordship.
Now, what else do you expect the DM to do?
Your lordship, they are not,
Who is not doing what?
your lordship, this the,
How do we say? You can only say that the authority under section 14 of the SRPC did not record his satisfaction. We can understand that. But without recording the satisfaction, he proceeded in the matter. You tell us any specific instance, what do you want?
your lordship, the execution.
Execution is by
They
what?
keep on giving us date, your lordship.
No, nobody's giving you date.
Yes, your lord.
The ADM factually don't make any statement which would be bad, because you see, we are not supposed to direct the district magistrate. We can only remind him of the obligation of his under section 14. He is not to decide the issue. He is to help you.
Yes, sir.
Help you facilitate you in taking over the property.
Yes, sir.
That he does by sending police force, by a magistrate to oversee law and order situation. You take possession.
Your lordship, they are not accompanying us, your lordship.
Again, you have said that you the entire police party went. You also paid for it. 38,000 you paid in cash.
Yes, your lord.
Take instructions and tell us you have charged money and all that.
Can I go back? They have not placed the statutory requirements under the proviso rule section.
Which document they have not paid?
No, the affidavit declaring
Your lordship, once the order has been passed,
maybe they must also come with statement.
No, but that objection was not raised by the DM. Forget about it.
Understanding.
Then once you have you have not, and is that for is it for that reason that you have not recorded any? That we can't say this for the reason that you deputed one ADM.
That is already been done.
So take instructions and get back. But these are innocuous petitions. We can dispose it off by saying that if satisfaction has been arrived at by looking at the documents, the obligation of the DM should be discharged. MSK Sharma. Yes, sir. Ms. Sharma, Leonard Hamilton, correspond number 235 and 6, seek some time to take instructions. Let this matter come up on January. Unnecessary petitions also come.
Yes, sir.
Unnecessary.
No, your lordship, they have to help us, your lordship.
Anyway, but you have to file your petition with the specifics. I don't know, you have gone all over saying so many things,
Yeah.
but you have not said something which would clinch the issue. You have gone over saying everything, and TG, police commissioner, police, what amount you have paid, except the main thing. I don't know. Anyway,
30th January. Item 13.
yes. Yes,
My lord, I have challenged the validity of the order dated 18/11/25 passed by the learned appellate tribunal, my lord, that your lordship will find at page 115, my lord.
Yes.
My lord, in this particular part, I find that during the proceeding before the learned DRT, I filed an application for scientific examination of sales deed, my lord, claiming that the original sales deed is.
can't do that. It is not necessary. Even if those documents you say were forged documents, you have signed it.
I signed.
Do you deny that you have signed those documents?
No, I do not.
This calls for a cost to be imposed on your client, and a heavy cost. You have defaulted, and you are using all wrong methods. You say that you did not deposit the title deed; it was found to be false. Then when title deed was verified, which you had signed, you say that it is
Under
not
duress.
under duress.
Yes,
So these are two things which do not go side by side. We are contemplating of imposing heavy cost on the.
My lord,
on
if your
the,
lordship is going to dismiss
petitioner.
it, at least the cost may not be imposed under the facts and circumstances,
No,
because the
what is
original is with me.
Now, first of all, you say
Still the position
just a
remains.
minute. You say it is fake, and number two, you say it is under duress. Now, this was done a long time back,
Yes.
and you are finding it now. I mean, this is not the way you defend yourself. I mean, I'm not talking to you. Your decision.
Yes, yes,
Your decision is
I
not bad to
understand.
file a petition, but then you take our decision. We are imposing cost of 1 lakh, wasting the time of the court.
My lord, because
We are
so far this.
always very accommodating. We don't dismiss petitions at the threshold without going through it. But this is fraud.
Your lordship may, if your lordship is not inclined to grant me the relief, my lord, let it be dismissed. But at least the cost may not be.
If we record the findings, we must impose cost. The way you have handled. Don't press it. We'll let you go. We give you a safe passage.
Yes, my lord. In that case, I am not going to press.
After some argument, what is this? Advise your client not to do this. He will get prosecuted.
Ah,
He is making false statements at every stage. Anyway, if you are withdrawing, we will not
Yes.
say anything further.
yes, my lord.
Mr. O.P. Bhatti, learned advocate. After some arguments, Mr. O.P. Bhatti, learned advocate for the petitioner, seeks permission to withdraw this application. Dismissed.
Much obliged.
Item 14.
Just 1 minute, Mr. Counsel. Give us 1 minute. Give us this Assisted Reproductive Technology Regulation Act 2021. What is the cutoff age?
Yes, it is 50 for women, 55 for male, lordship.
And you want a direction from us to the, just a minute, to the IVF center to start medicating you for IVF when the woman is 55 or 53.
53.
How can that be done?
Lordship,
No.
Lordship,
Are you challenging that provision? Then we hear you.
yes, Lordship, at the same time, Lordship,
Then you're questioning the virus of that
seek one,
or the constitutionality of it.
Lordship, Lordship, at the same time, Lordship, prayed before this honorable court, this, Lordship, to constitute a medical board. That whether my position,
It is beyond law. You question the correctness of this act of 2021, we will answer it now.
Lordship,
You question it, we answer it now. Will not take much time.
Lordship,
And these are, technical decisions in the domain of the government. There are many, inputs from medical world. It controls Down syndrome. It controls maternity deaths. How can you question this policy of age, the cutoff age, 55 for male and 50 for female?
Lordship.
And when you say that there is unnecessary distinction between male and female, you are absolutely wrong. That has got nothing to do with gender, but in fact, the physiognomy. That has nothing to do with gender. So question it, we will answer it. It will be a very interesting question to answer.
Lordship, at the same time, Lordship, I have some orders from another high court, Lordship.
That is not.
In-
Tell us if there is any judgment from Supreme Court, tell us.
The Supreme Court, Lordship, at this stage, I have not.
23 and 23 is related to this case, madam. Today's release, madam.
We'll see when it comes.
Lordship,
The lawyer appearing in 23, looking at our view, is not ready to have it dismissed along with this case.
Lordship, at the same, Lordship, my notice may go against.
We are extremely sorry that the couple has not been able to bear a child.
Lordship.
IVF failed. They want IVF again. In the meantime, 2021 Act comes
Lordship,
with the cutoff date.
Lordship.
You say that ask this IVF center to start medication immediately.
Before that,
And,
Lordship,
and why so? Because the rule is bad. So you have questioned the rules. Question the rules, we answer.
Lordship, Lordship, at the same,
Don't get altered, don't get frightened by our observations. These are only tentative. If you tell us something reasonable, we will change immediately.
Lordship, can it be, Lordship may pass a direction that to whether I am feasible for that treatment.
Why?
Let's,
Why?
one
If you say
consultation,
that my
Lordship.
age is less than 50, we can.
Last consultation, the last consultation, permit for a
Is
last
there-
consultation.
Is there any vested right of being treated afresh under the old regulation? Now the government in its health department decided that this legislation is a must. Can it be? If you don't have a Supreme Court decision, we have.
That is, that is in
That's against you.
connection with Surrogacy Act, Lordship.
The principles are the same.
Surrogacy Act, that is in
Surrogacy
challenging
principles are the same.
separate, challenge the separate.
21 G. Where is that act?
My lord, this is the Supreme Court decision.
Vijay Kumari, Lordship.
Just 21 G. Yeah. Productive act. एक और an interesting particular right. The clinic shall apply the particular about the other. Clear. Yes, which judgment have you given?
This was Vijay Kumar versus Union of India, my lord.
What does
Vijay
it say?
Kumari,
Vijay Kumar, yes.
Yes.
my lord. Here the same, my lord, in page number,
Page number?
my lord, page number 54, my lord. Paragraph 14, my.
it is 17. I'm not very perspective.
Is there a provider?
So therefore, there, that is there, Arun Muthuvel and others, the same thing.
Yes,
The paragraph
in-
that you point out
in-
is
in-
the, just a minute, paragraph that you have pointed out is the procedure by which this surrogacy or
Yes.
IVF is
Yes.
concluded.
yes,
We are not on that. We are not called upon to decide that
Yes.
practice.
yes, my lord.
We have been called upon to decide whether a process which, a medical process which had commenced,
Yes, my lord.
and in the meantime, new law comes,
Yes, my lord.
whether that process should be terminated. No, they say no, that's a transitional provision.
Yes, my lord.
Right, here it has not started.
Yes, not started.
Now, so therefore, this judgment
sir.
does not tell us.
Not, it
has
has
not
not started,
yet
this has not started, my lord.
Lordship, kindly say, Lordship, we had started but failed in the earlier occasion. Lordship. Yes.
If it had continued, we would have permitted it to be continued till its final culmination, no doubts. If the health of the mother is important, the process has started cannot be terminated just like that. But it was over. Now you want a fresh. And why do you want to do it? That's again your choice. We don't know.
But Lordship, I started in a Lordship, last consultation, Lordship allowed us.
Your only ground is that you are on a long journey of fertility treatment.
Yes.
And therefore, this law should be relaxed for you. Unfortunately, sentimentally speaking, we can say yes, but legally speaking, absolute no. They can't. And which doctor will undertake this risk? And there are penal provisions.
Lordship,
Penal
penal
provisions.
provision is there, Lordship.
I don't. And these principles are non-derogable. We have heard Sri
J.K. Goswami.
Mr. J.K. Goswami, learned advocate for the petitioner. Both couple, the couple has filed the petition
Yes, Lordship.
for the petitioners, and MS Bora for the respondent.
एक गाय एक गाय
One MS so and so for the respondent. I'm sorry for the name. All of you look alike in your dress. The petitioners, a married couple, undergoing infertility treatment for several years, seek a direction to the respondent IVF clinic to commence ART treatment. Is it called IVF treatment or ART? To commence ART treatment.
Yes.
The request was refused by the clinic on the ground that under section 21 bracket G, Redwick Rule 14 of the Assisted Reproductive Technology bracket Regulation Rules 2022, the maximum permissible age for a woman undergoing ART is 50 years, whereas the petitioner wife here, is presently 53 years old. It is the contention of the petitioners that because they have been on a long fertility journey and had initiated treatments prior to the enactment of the 2021 Act, they should not be denied the fruits of medical progress merely because they have crossed the statutory age bar. it is contended that the age limits introduced in the Act is rigid, rendering the entire architecture of the Act vulnerable to scrutiny. Such mechanical regimes under the Act violate Articles 14 and 21 of the Constitution of India in particular. There is no, as it were. This court therefore has been called upon to decide whether the statutory age limits for ART treatment of 50 years for a woman and 55 years for a man could be judicially relaxed for a couple who had already been pursuing infertility treatments prior to 2021 Act. Section 21 of the ART Act 2021 expressly prescribes that no ART clinic shall conduct ART procedures on a woman above the age of 50 years and on a man above the age of 55 years. This is a mandatory prohibition reinforced by penal consequences under sections 26 and 27 of the Act for clinics violating statutory conditions. For the reason of the age bar under section 21 being explicit, categorical, and admitting of no exception, the prayer made on behalf of the petitioner is not acceptable. So these are this is a policy framed. No, this is not a mere guideline or an advisory. This is not a mere guideline or an advisory criterion. But a clear prohibition backed by criminal liability. That apart, policy decisions on medical eligibility lie within the legislative domain. More so in these matters, which involves complex inputs on medical conditions like maternal health risks, success rates, ethics, fetal outcomes, societal implications, etc. The Supreme Court has consistently held that such policy choices, resting on scientific, demographic, and ethical consideration, are within the legislature's domain and not amenable to judicial second guessing. Unless manifestly arbitrary. Reproductive anatomy could be a part of Article 21 of the Constitution. But it cannot be an unregulated right. Thus, all ART procedures have to conform to the policy decision in that regard. We therefore find ourselves totally, we therefore find the petition to be meritless, despite having sympathy for the couple who have not been able to bear child, despite their best efforts. Dismissed, but without any order as to costs. As a dismissed, full stop, cost easy.
Item 15.
May I please?
One second. Yes, Mr. Chakravarti, tell us one thing. We have no objections with the order of the tribunal.
Lordship.
But, once it was quashed by the High Court, no?
No.
Okay.
Correct, Lordship. That order has not been challenged by anybody, Lordship.
He has not challenged it.
He was not a party to that.
Well,
He
I
could
was
have,
not party.
he could have,
He was not a party.
he
it
could
was-
have,
No, so, but he has challenged this subsequent, revival of that
Revival,
panel
yes.
and the employment
Lordship,
and the promotion to 18.
Lordship.
Ah.
But that
That
order remains, Lordship. They challenged that order, withdrawal order.
That's all right.
They succeeded and Lordship, we appointed
That's all
them.
right. So that he is not required to challenge.
Consequential order we had challenged.
He has challenged the consequential order, but with an impact.
In fact, both
No,
ought
no,
to have been decided
No.
together.
That was a wrong question that I put to you. Now, question is this. He questioned the result
Lordship,
in the first instance when the result was announced in 2022.
Lordship.
The tribunal, believing his statement that there was rampant corruption, no proper marking, quashed the entire panel. Is that the case?
No, tribunal did not.
Tribunal did.
We of our own, we
Acha,
cancelled
you
that.
of your
We
own
went for a
hands
fresh select.
cancelled.
And
The tribunal set it aside.
sat it
But
aside.
that was in his favor.
No, he was not a selected candidate.
Okay.
He was not a selected candidate.
My lord, initially there was a selection, that selection, there was a rampant irregularity and corruption. That is why railway itself, my lord, cancelled the selection.
And the
But the
selected
tribunal, the selected candidate
went to the
approached the
tribunal.
tribunal, and tribunal said, my lord, no opportunity was given to the
So
selected
therefore-
candidate.
therefore,
That is why.
Therefore, Mr. Sharma, therefore, your grievance now is against that order of the tribunal,
Lordship,
because this is a fallout
in
of
disguise,
that order. We
indirectly.
we had understood the facts differently.
Lordship may kindly see.
This you cannot do. तो cancellation certificate कर दिया तो अब तो उसका follow तो ये है ना कि the panel will revive with the cancellation, with the setting aside of the cancellation by the railway, the panel automatically gets revived because there is nothing which says that this panel will be this panel would lapse after 2 years or 3 years. It's in continuation. Your allegations were found to be incorrect.
My lordship,
Railways agreed with you, but the tribunal did not.
the tribunal only set aside my lord, the order of cancellation.
That's
Only
right.
on the
So
ground, my lord.
what
no
does it
force-
mean? What does it mean?
Immediately, my lord.
Just a minute.
My-
If we dismiss the petition, what does it mean?
My lord, the panel revived.
The claim is lost.
Yes, my-
Therefore, the railways took a decision of cancelling the entire examination result.
Right.
On your suggestion that it was imbued with a lot of corruption and what to say, irregularities and everything.
My lord,
The tribunal found that no, it can't be done. This is not their private affair. So many persons participated, correct? There was no specific instance of any wrong marking.
that was not the case, my lord. That was not the case.
Why was it quashed?
My lord, the lordship may kindly see the operative portion of the tribunal's order.
No, that's right. No, for
The
whatever reason.
tribunal initially, while setting a
It's not the case, but it has been called. So the entire it is revived. So you were against the revival of the panel.
yes, my lord.
So you should have questioned that decision. No?
My lord, because I was not the party in the
You may
said
not
proceeding, and I have came to know, my lord,
Why do you people forget this Star Babu Khenji and others? Any decision which affects you adversely, you can file an appeal.
but I would
Any
like,
decision.
I'd like to, my lord, point out the operative portion of the initial order of the tribunal, which was challenged by the my lord selected candidate. My
No,
lord,
no,
that
you file your response, Mr.
Yes.
Chakravarti.
There a private respondent also, Lordship.
First, at the threshold, we are not interested.
Lordship.
18 persons appointed, we will not disturb them. You file your response
Lordship.
because it is coming for the first time.
Lordship.
Let Mr. Sharma not have a feeling that we are hurrying with him. But we can discuss it up to that. Anyway,
Notice-
Mr. B. Chakravarti, learned Central Government Council, seek some time to file a response to this petition. Let this matter come up for consideration on so and so date.
there are private respondents also.
We said that private respondents will notice only when we are satisfied about your claim.
My lord, my-
Otherwise, we will not just issue notice mechanically so that all of them come, engage lawyers and throng this court unnecessarily. You have to first make out a case for us to call them. Prima facie, we are not inclined.
my lord, I'll satisfy my lord.
This is just a long lease, long breathing life to you.
Consolidation.
Yes, next.
Obliged, my lord.
4th of February. Item 16.
Here, I'm filing the affidavit today. But they have informed that they need 6 months time to complete the work. The construction of bridge in question, I'm filing the affidavit, they have paid for 6 months time to complete the work.
Now, 62% of the work,
65% has been done.
62 was the statement of the minister in the floor of the house.
My instruction is that 65% logic. The rest they will do, and
All right, what affidavit you had filed that you had to withdraw? I mean, it was in our presence, but I'm forgetting it.
logic. Well, in that affidavit, actually, we could not indicate the time, how much time they will need. That we could not indicate.
And what affidavit have you filed today?
But indicating that they pay for 6 months time.
You have filed or you are yet to
No,
file?
we are in the process. We are filing
Mr. D. Nath, learned senior government advocate, Assam,
for the
has
response number
submitted
3.
that the affidavit required to be filed on response number 3 is going to be filed course of the day. With a copy in advance to the council for the petition.
I'll do.
to the council for the petition. Let this matter come up for consideration. By February, what percentage of work would be complete?
I'll update, madam. I'll update.
Expected, you must have filed that affidavit. What have you said in that
But
affidavit?
the affidavit, we said that they, in 6 months' time, they undertake to complete the.
6 months is a long time, no?
No, that's true, but some, well,
It's a bridge.
it's a breeze and two well boring are left open up.
16 March.
Are left up.
Item 17.
Lordship, item 17, Lordship had prayed for an adjournment to the Lordship. The only reason we did not circulate an adjournment slip was because there are few IS pending, Lordship, which is being moved by an outstation council, Your Lordship.
Your Lordships, I appear, the councillor is referring to me. We filed 6 implement applications, Your Lordships. We were the original writ petitioners. And the main arguing counsel is unfortunately on his legs before the Honorable Supreme Court, so he's not connected. But if Your Lordships could grant a passover or an adjournment.
As per it, yes. 1.1. As per it. Who appears for an IOR? Have you brought those notifications? What is it?
I filed a petition.
You filed an You've done your part.
Yes.
You have the records of the schools.
No, Lordship, state authority.
Anyway, who is the advocate who is leading you, MS Singh?
His name is Mr. Mandeep Kalra, Your Lordships.
All right. As prayed for on behalf of the appellants and some of the applicants, let this matter come up for consideration. We will fix it in January.
January, Lord.
So grateful, Your Lordships.
January some date. We have almost heard it, no? 18 months diploma, which is all right.
28 January.
Lordship, could it be day after 29th, Your Lordship? Could it be on the 29th, Your Lordship? Hearing day, right?
29th would not be possible. It will not be taken up on 29th. So we keep it in February. Is that
On 30th, Your Lordship.
comfortable for you, MS Chitrangada, as I can see the name from here?
Yes, Your Lordships.
All right.
On 30th, Your Lordship. 30th of January, Lord.
No, February.
Lord.
Yes, Mr. Advocate.
I'm available every day, Lord.
On 4th, Your Lord.
But for few matters, you are
It's
available.
too far away to plan, Lordship,
Huh?
for me. It's too far away for February. I cannot say right now. That's it.
4th of
Lordship,
February.
give a day. In case if any difficulty, we will solve.
Item 18.
Deeply obliged, Lord.
Wait, Your Lordship. Lordship, can you pass over the matter for the time being, Lordship?
What time being? What time? 10 minutes, 5 minutes, half an hour?
Lordship,
We
after
will
half an
come back,
hour.
we will come back by 12.
Sorry.
If that's okay, otherwise you take time. Once we start hearing another matter, we'll not get back to the old matters. So if your counsel, who is leading you in this matter?
Senior Counsel BD Dash, Lord.
Mr.
BD Dash.
BG
Senior
Das.
Counsel
If
BD.
he's free by 12, ask him to come. We will wait for him.
Okay.
And we'll get up for, then we'll be back by 12.
Very close to the assembly.
Item 18.
Another page 32. Question is, what is the way forward? Court has found that the non-communication is bad. That Your Lordship will get it at page 33.
What happened? Just give us some facts.
Page 32, Your Lordship will come.
32, all right, but what has happened? What have you come here for?
That ACR, that paragraph 15, my lord, page 33. Court has found that the non-communication is bad. and directed, my lord, you file, they will communicate now, then thereafter, you will file representation, it will be considered. According to me, my lord, subject to your lordship's 2009 6 SCJ Abhijit Ghosh case, it says, my lord, if it has not been communicated, it cannot be acted upon. So the matter,
That principle, applying that principle only,
yeah,
the downgrading you to
Yes.
good or very good
yeah.
was set aside.
Not set aside, it says, well, they will now communicate it. Paragraph page 33, page 15, paragraph 15. Now they will communicate it and then I file representation.
Just a minute. So what is bad about paragraph 15?
My lord, paragraph 15 is, my lord, it has to be set aside because in the community, well, I rely only on one judgment, 2009 16 SCC.
The difficulty is, if the difficulty is that you question it in the wrong way, no? There are certain promotions which are based on ACR.
Yes,
So ACR, which is not poor, which is not adverse also, would be required to be communicated if it is being used for promotion
yes,
and it is being downgraded for no apparent reason,
yeah,
right?
not communicated
So
to me.
you should have said that it should not have been downgraded, which you could not have carried that petition for any length for the reason that is for the reviewing authority.
No, page 32, your lordship will kindly see.
No. So therefore, what is the way forward that you were suggesting?
Way forward, my lord, on the basis of the judgment 2009 16 SCC.
Let us see the chair.
Yeah. It has to be set aside, my lord, and the promotion should be considered on the basis of. Paragraph 8, last line, my lord.
Fine. No, keep it. Good.
Page number 146.
So did you challenge your not being promoted? Did you challenge that action of promoting others, leaving you behind?
That action we have not.
No, how can we pass an order in appeal in this? You said that this ACR was not communicated to me. The court said it must be communicated despite the fact that it is not adverse.
Your lordship will give me time tomorrow. I have also same thing in my mind. My lord, your lordship will
Question
give
is
me
this.
time.
Now we
Yeah,
are in
your lordship
appellate
is correct.
jurisdiction against a judgment passed by a learned single judge. You prayed what you got what you prayed.
No, my lord, at the same time.
Where
my lord,
have
we
you
pointed out-
impeded other persons? What has happened? You should have said that my the authority is not giving me promotion because of my ACR, which was not communicated to me, is bad. Therefore, I should be considered. We would have taken it to a logical
Your lordship
conclusion.
is correct, my lord. Your lordship will give me Monday, madam. Monday, let it be on Monday.
Just
Like similar judgment, your lordship will kindly go ahead, rather than single judge. That your lordship will find it at page 96. For directed promotion.
you had prayed for it.
The,
You had prayed
the
for it.
other party, my lord, the
No, you had
who are
prayed
junior
for it.
to
But
me,
the others who have been promoted would have
we have not made them.
because they fill up the vacancies.
Yeah, we have not made them parties. That is there. That is one thing. Huh? One post is vacant, I am told. One post is vacant.
What post is vacant? And we don't know that you were not promoted only because of good.
Well, the
grading.
marking is there, page 55.
Anyway, you tell
Page
us.
55, your lordship will kindly see. This is the marking to be taken. So if the good is gone, then I'll have to be acted upon.
If one place is vacant, then we'll say that this is okay. Yes, we have to hear this. Yes, Mr. Katne.
I'm not sure, my lord, whether one post is vacant or not.
Forget about one post being vacant. Now, I think Mr. Das has made out a case for his consideration for promotion. See, not consideration for promotion. No, that is one step further, Mr. Das. The post is this, that it was communicated, but we cannot, upgrade your
Not
benchmark.
update. My already is, it is there, page 32. my
No,
lord.
what we will say is this.
Very good to good.
Now,
and,
just a minute, Mr.
excellent
Das,
to good.
what we will say, what we propose to say, unless Mr. Khatniar comes out with some logical reason for us not to pass such order, we'll say that because it was not communicated, he could not appeal against that. He could not file any representation. Now that it has been directed by the single judge to communicate him, he will make a prayer for reassessment. He'll make a prayer. Once he is communicated good, he will make a representation to be enhanced to very good. If
Yes,
it is
I
enhanced, just a minute, if it is enhanced as very good, then one post be kept vacant so that he may stand promoted in case the department says.
Yeah, that
We
is-
can say
my
that.
lord, only.
I think nothing beyond that.
Yes, I think. Well, only one thing I just wanted to point out, subject to what your lordship may say, page 55.
Let us see. Let us see the order again, impugn order.
Page 33. And page 32 is the downgrading, my lord.
Page 33.
32 is the downgrading.
Just communicate the artwork. Conclusion. The result is petition allowed following the dictum of court there.
Lordship may kindly sit, sir.
Just a minute.
Yes.
I think what we were saying has been given to you.
Paragraph 32, your lordship.
No,
page-
paragraph 15.
Yes. My lord, I'll have to make representation. Then what will happen? My lord, if the downgrading still remains, I'll have to file
So
representation.
how can the single judge, how could he have, upgraded you?
No, upgraded, your lordship will kindly say they will have to page 32, your lord, for a moment, your lordship. Paragraph 14. The reporting authority has given me very good, very good. Accepting authority has given me a good. Same, very good, very good. Then my lord, excellent. Page, next page, excellent, very good, good. Now that, now your lordship, they are required to page 55, your lordship can say, for a moment, but page 55. This is the calculation. Very good has got 3 points, page 55. How they count? It is on the basis of this counting, they promote. So whatever I had, my lord, excellent, very good and all, they should not
So
consider the,
you will be representing to the accepting authority
yes,
or upgrading you to very good.
yes.
And in case it is done, then perhaps you can stake your claim for the post, the promotional post. The
Yes.
post on promotion.
My lord, only
No,
thing
that is what the single judge has asked.
No, but it has to be set aside, my lord, the downgrading has to be set aside. Because it was not communicated to me.
This downgrading has to be set aside means you have been given the liberty to make a representation to the accepting authority.
Yes.
Now the ball is in their court. They can say that we have not questioned the accepting authority. We have not asked them, why did you downgrade him? So therefore you make a representation. If it is agreed to, very good. We will say that without any reason, it was reduced to good from very good.
Yes.
But then the order remains.
Yes. As per the rules, my lord, communication has to be made within a period of 30 days. Therefore, that Abhijit Ghosh case, my lord, said the lord, my lord, your lordship will kindly see para 8 of the judgment. Last paragraph. Therefore, the entry is good if at all granted to the appellant. The same should not have been taken into consideration. So uncommunicated SCR report, they should not have been taken into consideration. So whatever is there, the excellent, very good, that should have been considered.
No, that should have been considered. This was the case where the concerned employee had retired. So what they said was that he may be considered retrospective promotion from so and so date shall be considered for the benefit of refixation of his pension and retirement benefits.
That is
So
true.
that could not have been
But the
done.
benefit
Here,
has
you're
been given.
still in service, long way to go.
Even learned single judge
Principle, right? So Lund single judge has followed the same
No,
principle.
no, no, learned
Abhijit
single,
Ghosh,
in another case, my lord,
Tasdikar is also on the same principle of Dedat.
another case, page 96, learned single judge, my lord.
Tell us the paragraph.
Paragraph 9, my lord. 9 and 10. The ACR for the year that was
Paragraph
set
9 and
aside,
10.
9 and 10, promoted with consequential benefit.
Paragraph 9 of the judgment, no?
No, paragraph page 96, my lord, if it,
No, tell us the paragraph of the judgment. We are at a different phase. In my file. Yes.
paragraph 90, page 96, paragraph 9. Paragraph 9, your lordship will get it at page 99.
All right. What do you want to show from there?
And from paragraph 10, your lordship will kindly see. From what has been expected herein above, this court is of the considered view that the case of the present petitioner is fairly covered and therefore a similar order should also be followed in the present case. The respondents are therefore directed to pass appropriate orders for an appropriate rectification of the ACR of the petitioner for the year 17-18, which will not cause any impediment for his promotion to be considered as on so and so.
Which is the internal page, Mr.
Page 100, my lord,
Of the
internal page. 5. Then it says, well, consequent upon such rectification, the respondents are
Page
directed.
of the
to-
judgment, impugned judgment.
Impugned judgment, my lord, not impugned, my lord. This is
Referring
a
a different judgment.
judgment relying, another judgment has been relied upon, my lord.
Okay.
Learned
Yes, sir.
single judge has passed another, this is another judgment, passed by honorable just coordinate bench, my lord. Single judge,
96.
96.
Okay. You should accept that, no? Then you're taking the.
Based on the Devdutt case and Sukhdev Singh case. Paragraph 9, your lordship will kindly see that the ACR uncommunicated ACR downgrading that was set aside.
We are of the view, sitting in a division bench, that this paragraph 10 is not sustainable.
My lord, ultimately, my lord, but because of
Question is
paragraph
this,
9.
that see, the judgment should be within the remit of the
Understood.
constitutional court.
That I understood.
We can't direct for that.
No, no,
We can only direct for consideration.
But on the basis of paragraph 9, I say, my lord, my submission, my lord. Paragraph 9, it is a Supreme Court judgment, Yugandhra Nath Singh case. That is repent. Oh, sorry, my lord, that is another.
Read that paragraph
another
9 which has been quoted.
Sorry, my lord, that is also another coordinate bench. Your
That's all
lordship,
right.
yeah.
But it doesn't matter.
It is well settled that any entry in the ACR, whether good or bad or adverse, are required to be duly communicated to the concerned employee. As the entry in the ACR resulted in the denial of promotion to the petitioner, it was bounden duty of the respondent authorities to communicate the adverse entry in the ACR to the petitioner. The said adverse entry in the ACR having not been communicated, court is inclined to hold the grading of the petitioner as average in the ACR for the year 2015-16 is bad in law and not sustainable as the petitioner had lost.
We would be passing an order in which would have the same spirit.
Well, then I leave it to you, Lord.
Will have the same spirit.
Then I, because if
But
I
we
give.
will not permit you to elbow out anybody who has already been promoted.
I'm not, because the marking system is there, page 50. My
No,
lord.
no, marking system, whoever have been promoted, they have been promoted, sorry. And inter-C seniority also will not be governed because you're getting promotion later.
Yes. Unless I
That is,
challenge.
unless you again file a petition and
Unless
get an order from the court.
I understand. But marking,
will not give you bucket full of reliefs here.
I
You'll have to
understand.
come back to us again.
Some sort of relief is also good for us. Because ultimately,
That,
my
Mr.
lord,
Khatiyar,
if
can
a
order.
question of communication doesn't arise.
The impugned judgment says this.
Judgment says
learned
they will
single judge says
communicate.
this.
Matlab, I know it, there is nothing to be communicated to me.
No. Read the conclusion
Yes.
of the impugned judgment of the single judge.
Para 33, my lord. Page.
Conclusion is in paragraph 15.
Yes. In the result, this petition stands allowed. Following the dictum of Devdutta's case, it is provided that a good entry in the ACR of him for the year 2000 so and so shall be communicated to the petitioner. Nothing
That is in the event of
petitioner forthwith, and he should be permitted to make a representation against the same. Unless this is satisfied, my lord, it will remain like that. The representation, my lord, it will be in, my lord, it will of the no use. Question of communication doesn't arise because I know it now. It has to be set aside. What I say, my lord, what this has to be set aside, they will have to consider what was the downgrading has to be ignored. This is what Abhijit Ghosh case also said. Of course, in that case, when the person retired.
That
But,
we can,
unless
we can do that.
Yes. Only we
Probably the single judge meant that, but
but
it was not
they-
specifically stated.
Yes, and that is true.
Yes, Mr. Khatne, any objection to this?
Otherwise, Malad, there is no wrong in the single judge order.
Something wrong. You have something wrong, no, not in the single judge's order, but you're not decision making. Your decision making was flawed. So far as Mr. Das is concerned.
But as regards the single judge order, Malad, he has given the liberty to file a representation.
No, liberty to take a first, the accepting authority, the decision of the accepting authority is set aside. Let him take a fresh decision. It's the same thing. We
Yes.
just put one word in.
Yes, Malad.
Take them. We have heard Mr. Das and we have heard Mr. P.D. Das, learned senior advocate for the appellant and assisted by so and Mr. Khatne for the respondents. For the respondent. The appellant challenged the downgrade.
Can I leave, my lord?
Yes, please.
In some court, we don't get fast over time also.
That's right. That's right. You can go. Your junior will
My-
communicate to you what we dictate.
I'm deputy now.
We will say that. We will set aside that downsizing,
Downside.
downgrading, and then we representation.
We'll
But
try.
we will not say that you will be marked very good.
That we will have to come by way of another petition. I take your lordship's advice. Sir.
All-
Deputy.
we will not say anything. We will not say that it shall not be considered for your inter-C seniority and all
No,
that.
no.
We leave it open.
But yeah,
All right. We have heard Mr. P.D. Das, learned senior advocate for the appellant, and Mr. N.J. Khatne, the learned standing counsel for education department for the respondent. The appellant had challenged the downgrading of his annual confidential report for the year 2019 to 24, which allegedly marred his promotion, marred the prospects, which allegedly led to his being excluded from the benefit of promotion to the post of Joint Director Cadre, despite his seniority and unblemished service. The appellant was appointed in the year 2013 as a Deputy Director / Inspector of Schools / District Elementary Education Officer, (DEEO), through Assam Public Service Commission selection, and had served the department diligently. He was posted as Deputy Director in the Directorate of Secondary Education since March 2021. Under the Assam Education Service Rules of 1982 and a 2019 government guideline, next promotions, the promotions are promotions are based on marks awarded on the basis of 5 years ACRs. Though the appellant was awarded very good for all those 5 years, for all the preceding 5 years, by the reporting authority, the accepting authority, without recording any reason, downgraded such marking to good. Based on this downgrading, others could steal a march over the appellant. The downgrading of his grade by the accepting authority was never communicated to the appellant for him to have represented. But by then, the appellant had already lost on his promotion. When he approached before, this led to the filing of the writ petition seeking setting aside of the downgrading of his ACR grade awarded by the reporting authority, and for directing the respondents to redo the promotional exercise with respect to the cadre of Joint Director as per the provisions of Assam Education Service Rules 1982. The appellant had also prayed for grant of retrospective consequential promotion benefits to him whenever granted to the income to him, whatever was granted to the persons who were junior to him, as also for directing the respondents to consider his candidature for the post of additional director in the event of the junior officers promoted in the cadre of Joint Director by notification dated 15/2/2020. The learned single judge, relying on the proposition of law laid down in Devdutt versus Union of India and others, 2008, 8 SCC 725, Sukhdev Singh versus Union of India and others, 2013, 9 SCC 566. Held that it was inappropriate for the respondent not to communicate the downgrading to the appellant, even if after the downgrading, the grade allotted to him, the grade given to him was good, which is not an adverse end. Preventing an opportunity to him to represent against such downgrading. In Devdutt Supra, it has been held that non-communication of adverse remark deprives an employee of the opportunity to seek rectification, which is violative of Article 14 of the Constitution of India. And that even good entries may become adverse when a benchmark of very good is applied by the Departmental Promotion Committee and non-communication of the same to an employee deprived him of the opportunity to make representation against such remark and consequently denying promotion to him violates Article 16, bracket 1 of the Constitution of India. And that non-transparency has the effect of diminishing the administrative efficiency and lowering the morale of the employee. The same view was taken in Sukhdev Singh Supra. As noted above, relying on the aforementioned judgments of the Supreme Court, the learned single judge directed as follows. Paragraph 15 to 17. Mr. Das, learned senior advocate, has questioned this judgment on the sole ground that his being relegated to the accepting authority to make a representation to him for reviewing the downgrading, reviewing the downgrading of his downgrading of his what is it? Downgrading of his assessment from very good to good. What have I said? Just to start this thing. Louder, I can't hear you, Khan. Would be rendered meaningless if the downgraded rank, downgraded mark is not set aside and the accepting authority be asked to pass necessary orders making a fresh assessment for grading the appellant. From a reading of the directions given by the learned single judge, we find that we find that the directions amounted to the same but not explicitly stated. We therefore deem it appropriate to modify the judgment of the learned single judge to the extent that the downgraded ranking of the appellant from very good to good is set aside on the for the reason of the same having not been communicated to him, and the appellant is given the liberty to approach the reviewing authority with a representation to reassess him. If in the assessment of the accepting authority, the appellant would be required to be graded very good, that shall be taken into consideration by the respondent for promoting him to the higher post, provided the promotional post is provided that any promotional post is vacant. We will not go any further. A promotional post is vacant. With the aforementioned modification, the appeal stands disposed. We have not said anything with respect to inter-C seniority. You'll have to come again. And this additional director post, that is too far-fetched. Yes.
Item 19 to 22.
Yes.
Lordship, please.
May I please? Your Lordship, that is, we have received the entire encumbrance amount. But the petitioners is keep on delaying by not communicating the exact amount and.
Just a minute. If you are ready to give them the first charge.
Yes.
On the amount which you got out of auction. I think they would not have any grievance left.
My lord, just
Your
taking up
Lordship,
item number
there-
20, my lord.
No,
There
we
are
are-
three,
we are-
four matters, my lord, to be listed.
So
One
let's
is
see
that,
the principle first.
yes, my lord.
Now you are claiming the first charge
Yes, my lord.
because there is explicit reference of it in the Assam Tea Plantation Provident
Provident Fund
Fund, Pension Fund Deposit Linked
Yes,
Insurance
Lord.
Scheme Act. Which is that provision?
Yes, my lord.
Your Lordship, there, section 10, Your Lordship.
10.
That is priority of payment of contribution over other debts.
Read.
Yes, my lord.
You're Mr. Puken.
Yes, my lord.
Yes, read that paragraph.
Yes, my lord. It's, lordships has it.
They will take some time to get me.
I see, I
But
just.
you can read.
Yes, in the mind. The amount due in respect of any contribution under the scheme, the
Assam Tea
amount,
Employees Provident Fund, Assam Tea Plantations Provident Fund and Pension Fund and Deposit Linked in the Lamba. It's an scheme act of 1925. You have two spare copies of the act,
yes, my lord, I just checked.
one from you and one from him.
Yes, my lord.
In fact, before commencing your argument, you should have given the slip of even the bare acts to the court.
I'm actually, my lord, we were not very sure in regards to the status of the matter. These matters were actually before the list, before the single judge, but they've been mentioned and brought here before your lordships, because the first order that was lordships will see was before the single judge. I was in,
Why has it come before the division bench?
I don't know, my lord, because the first order, my lord, if your lordship should see it, my lord, I have that order with me. In fact, that is a clarification that's been mentioned and brought before this, because that, my lord, I'm ordered dated 14/12/2022, my lord. In terms of which it was said that the DRT will continue the proceedings and pass an order, but everything will be subject to outcome of this petition.
Order is 1911.
Yes, but that was subsequently mentioned, my lord.
1911 of 2003. My order.
No, I am not for the second. Your Lordship, it is item number 20, not this item.
Lordships are taking item number 20.
I am for 19, Your Lord.
He's for 19, because there are 3, 4 matters listed, my lord.
No, but who appears in item number 19?
19, I don't appear.
19.
If your lordship sees order dated 12/25, there is a direction by this honorable court that they can go ahead provided they show our amount in the demand in the auction notice. 19/25, your lordship.
19.
19/12/20, 12/25.
12 to 2025, Your Lordship.
Yes, lordship pursuant.
Just a minute.
Yes.
That's right. So I think half your battle was won.
Yes.
Your
Now,
Lordship, we have accepted
Just
the.
that you will not allow, that is, you
Sorry,
started
sorry,
in 22. Now we are looking at 21. Let him complete, no?
Sorry, Your.
Please take yourself. Don't
Yes.
feel sorry about anything, but we'll hear you.
Yes.
We will hear you.
Yes, Your.
Yes.
Yes, lordship, what has happened now? There was a successful auction bidder who has paid the bank dues, and he was supposed to pay the PF amount also. But the PF amount was not paid. So the sales certificate has not been issued by the bank.
Wonderful.
Ah.
This is because of the undertaking given Undertaking. given
undertaking it, but
Before the order dated 12/2/2000.
Right, Your Lordship. So the
Oral
P-
undertaking.
yes, so the PF amount was supposed to be paid to us, but since he has not paid, sale certificate has not been issued.
Wonderful.
However, the owner forcefully entered into the garden and has been managing the garden now. That's my instruction. And he has been deducting.
That's something which is different from the records.
Right, right. So now he has been deducting PF dues illegally. So that is the situation which I want to bring on record by way of an affidavit. But be that as it may, in the meantime, the union, the labor union or the workman union has filed a writ petition challenging the very auction notice on the ground that the workman dues were not shown in the auction notice, which is illegal, which your lordship has examined the matter, and that matter is tagged along with this matter, and there is a stay.
Which is that?
That is item number
22.
22.
Give me 20. All these matters are here because now we can understand, because one of the matters was here,
Yes, madam.
and therefore all these matters
That's
have been
what I
tagged.
filed, my lord, item 22.
Azil is page 22. 22.
That's right. But so we have this no sale confirmation, no sale order being issued is pursuant to this order.
Yes.
Yes.
So I think your lordship, these two matters needs to be heard together. But in 22, I have been informed, 22, I am the respondent there.
Yes.
But I think steps has not been completed. They have taken steps, I have been informed by my learned friend here. So
22.
22,
Official case.
they have taken the steps. So this all matters can be heard together.
And who appears for the purchaser?
Purchaser, I think steps.
No, your lordship, he has not yet been included, your lordship.
And you represent who?
No, I am representing 2 and 3 Union Bank of India.
No, the
Because
purchaser-
the sale certificate has not been issued yet, your lordship. That is why he is not having any vested interest. Frankly.
In trade unions.
Purchaser is the party here.
It's a
Party in this
my
petition.
I will issue notice.
A
Your
notice has
lordship,
been
one small submission.
Issued, my lord.
Notice has been issued.
Yes, my lord, and on
Yeah,
the
yes,
last
sir.
occasion, my lord had actually granted us time to complete the service on 6, 7, and 8.
And you have.
No, my lord, I couldn't do it. There was a slight delay. We've done it now.
Take down. Let all these matters come up consideration.
May I please, your lordship?
Yes.
One small submission. Your lordship, that we have sold the property on 30/7/2020.
Can't help it. You can't help it. The purchaser must be here. You don't want him to come.
No, your lordship, that is.
You said
your
that
lordship,
he does not have a vested right. You have auction sold it to him.
yes,
And you see, you
he
say
is a
there's no
successful
vested
bidder,
right.
your lordship.
He is the successful bidder, all right. He is above the reserve price of 9 crores, all right. Is that the sentence?
No.
Tea garden, tea garden
garden,
taken up.
yes,
Ah,
yes.
the reserve price was 9 crores. Why do you say no?
Yes. No,
Why
your
do you say
lordship,
no? We record all such facts
No, no.
here, no?
I am on something, your lordship, that we are ready to deposit their amount. 2 crore 23 lakhs has been deposited by him. So once he will get the sale
Sell that
certificate,
amount and we will permit you to issue the sale certificate.
the amount of.
The PF.
You come up amount of PF, only
Yes, your
PF.
lordship,
Other
they
things-
communicate, your lordship, they communicate tomorrow, your lordship.
Communicate to them.
Yes, your lordship.
The letter-
What they are doing, your lordship, they keep on telling us, no, this amount is not. On 5/7/2025, when we have issued a sale notice, we have confirmed an amount, 2 crore 23 lakhs.
Why are you so protective about your purchaser?
No, I am not protecting the purchaser, your lordship. I am just submitting before your lordship.
How has he entered the tea garden?
He has entered postally
No,
because
no,
he doesn't
he
have
has
the sales
visited, I think, he might have visited before purchasing, but he has not taken any charge there. Or if there is anything has been happened, I do not know.
It's a bank letter.
Because
Your
before
Lordship.
purchasing, he has visited.
The Lordship may see these two letters where the bank itself has written, where sales certificate had not been issued. And they have informed the labor company.
This is a good ground for cancellation or that's it.
Maybe, Your Lordship.
And the bank asking to return that money to him. After deducting.
Your Lordship, 11 years, Your Lordship, 11 years, this garden is not being running.
We understand that, but we are concerned, but we are concerned about those tea plantation workers also.
Yes, Your Lordship. We are also concerned. That is why we are.
You're not concerned.
uh,
You're concerned with your business.
Your Lordship,
That's
definitely.
good.
My
You're-
first
you're-
objective is to.
You're not a charity giving organization.
Yes.
We don't have any complaints about that.
Yes, sir.
All right. You have to run your business.
And Your Lordship, recently one judgment has decided everything. That is, Your Lordship, if Your Lordship will allow that everything will be free, Your Lordship. Otherwise, someday another writ petition will be filed before Your Lordship by some other groups.
No, once you give the same certificate, after.
No,
they
no,
have
I am not
paid their-
issuing. I have not issued.
After that, see, the money you have received.
Yes.
So the distribution part, disbursement part is your business.
Yes, sir.
So therefore, in that circumstance, you may be right that we need not call the purchaser. You have received that money, no?
It's completely yes, sir.
So you offer the account,
Yes.
you settle the account.
Yes.
It should be PF and other, necessary expenses,
Yes.
all to which you are entitled
And statutory
under the
interest.
statute, all statutory payments.
Before Lordship may see the second page.
He will not see any pay. You give the statement of account. If you don't want to give it to him, give it to us. We will give it to them. In that case, you may not be able to say that this figure is tentative.
We
Give it to us, we'll give it to them.
The bank itself has written that they have not yet received our dues, the second letter. The bank itself
It
has,
is
that's
with
the
us, Your
official.
Lordship. It is with us.
Why do you want, why
I-
do
I
you-
will
why
inform-
you are sitting, Mr. Sharma? It's unnecessary.
Yes.
You are getting back to the old communication. Today, the lawyer says that everything has been paid.
Yes. I'll communicate.
He's in a hurry to issue a sales certificate, but for the leave of the court. Why are you questioning that?
Money is lying in suspense account.
I know.
And we'll intimate immediately our
You
dues.
give a copy to us.
Yeah.
We will not allow you to have a prevaricating stand.
Yes, sir.
You are only the association.
Yes.
No,
No, I'm the PF.
he's a PF.
He's a PF.
Or you're the PF. All right.
But item 20 will maybe detect, it has nothing to do with the other matter. It's been wrongly mentioned in tag along. On a completely different issue.
Doesn't matter. Now,
The-
all
that
such
is also
transactions
not-
should be complete.
The apportionment of dues is pending, my lord. The proceeding before the DRT were trying, they have been all.
Let it be there. First chance, DRT would say what?
No, no,
It's the same thing.
it was, there is an interim order passed by this honorable court, my lord, there was a single.
Anyway, we'll see it on the next day.
Yeah.
Give us the accounts. We are not saying anything.
Yeah.
For the reason of DRT, DRT pendency of a petition in DRT. Yeah. At the request of the land council for the petitioners, let these matters come up for consideration in priority on. We give a date in first week of February with
Your
priority,
Lordship, maybe in January, Your Lordship.
with January. All right.
I
All right.
unnecessarily tag.
We'll release you on that day.
Lordship.
Without looking at the records, we will not say unnecessary tagging.
And Your Lordship, in the event of communication, we are ready to issue a draft.
You do that. Where is the embargo? We have not said anything.
Yeah.
Issue the draft. That day it will be only a formal, closure of the petition.
Yes, Your Lord.
Rashmi only indicated item number 20, which has been tagged to the lordships. If it is on that day, could be seen. If it is to be decided, otherwise it can go back with the signature. It has to go back with the signature.
At number 22. At number 22.
20.
Okay, it appears that WPC number 8022 of 2022 has erroneously been tagged along with other cases, namely WPC 6583, 6560, 4994 of 2025. Let WPC number 8022 of 2022 be tagged and we sent, and the records be sent before the learned single judge where it was pending. All right?
2801. Nice.
Oblige, your lord.
Item 23 to 25.
What instructions did you get this surrogacy thing?
Lordship, I have received instructions. She says, Lordship, that she requested me to place the case before your Lordship.
Yes.
Lordship, may kindly say that my case probably covers, Lordship, similar to petitioner number 3 in that judgment, Lordship, passed by the Honorable Apex Court. In that case also, Lordship, the applicant number 3, she failed in January 2022 and subsequently she was allowed, Lordship. That part, Lordship, may kindly say.
I had asked you a simple question.
Lord.
All the process, the surrogacy process, it had failed. It had started, it had failed.
Failed.
Now a new regime is there.
Similar to the applicant number 3 in that judgment, Lordship. In that case also, it failed, Lordship. And, Lordship,
In that case, the second process had already begun before the new regime.
no, Lordship.
Yeah.
Lordship, may kindly have a look at paragraph 5, Lordship. Of that order, Lordship, Vijaya Kumari.
Vijay Kumari.
Yes.
Yes.
Oh.
Today, am I there now? Yes. Which paragraph?
In writ petition civil number 809 of 2024, starts with
paragraph?
paragraph 5, Lordship. Probably, Lordship, I'm holding the copy which was downloaded from that website.
Copy of that judgment? Yeah. Please pass. Please pass. Doesn't matter even if it is marked. Yes.
Paragraph 5, Lordship, may kindly have it.
Yes.
Paragraph 5 here, Lordship, that I'm sorry, Lordship, paragraph 6 also, Lordship, 6, that regarding applicant number 3.
Which will say that the process was continuing.
Lordship, paragraph 5 is
contain-
continuing,
it
paragraph
got-
6, Lordship, relating to that, it completed, Lordship. Paragraph 6, the applicant in IA number 181570 are hereinafter collectively referred to as intending couple number 3 as on date of the application so. The applicant husband was about 62 years old and the applicant wife was about 56 years old. Intending couple number 3 lost their only child in 2018. Although they desire to conceive a child naturally, again they have advised to opt for in vitro fertilization, IVF, due to their advanced age. In May 2019, the applicant wife underwent an examination and was deemed fit to bear an embryo with donor of kidney. However, due to the presence of fibroids in her uterus, it was advised for IVF be persuaded for donor egg. The applicant wife then underwent mammectomy, laparoscopic surgery on 22/11/2019 and was nonetheless deemed fit to bear an embryo. Intending couple number 3 submitted that the process was subsequently put on hold due to COVID-19 pandemic, during which the applicant wife developed hypertension, due to which the couple received medical advice that surrogacy was the advisable course of action. Having decided to transfer the embryo to the surrogate by April 2021, the applicant submitted that this process was further delayed by second wave of pandemic. Subsequently, although the embryo was successfully transferred to the surrogate mother in January 2022, the surrogate mother suffered a miscarriage and the pregnancy was not successful. So thereafter this act came and they was divided. Thereafter the act, the rules were enforced and intending couple number 3 has been rendered ineligible for undergoing surrogacy procedure, since both applicant wife and husband are above the age limit of 50 years and 55 years respectively.
Here this was because here the process was not IVF but donor eggs.
Lord.
Now, first attempt at a surrogacy with another female who offered, that failed. Again, another eggs were implanted in her embryo.
Lord.
So therefore this continued.
Yes.
The embryos were ready to be transferred to the surrogate mother.
Yes.
So therefore the process had begun.
Yes.
It may have failed, but it
Yes.
had begun before 21.
In my case also,
This is what we see.
and Lordship, may I hand over one thing? Lordship, may I hand over a copy of single bench order of Delhi High Court, Lordship, relying on the same judgment, Lordship, where Lordship process already stopped, then it was allowed.
How old is the mother?
Presently, Lordship, at the time of filing writ petition, she was 49 years in 23, now 52, 53. Now around 52. Lord. And here also, Lordship may kindly have a look at page 3. The designation is down below. Here also, embryos were frozen till 12/7/2021.
Now, where is your statement that the embryos
Lord.
have been cryopreserved
Lordship.
for it to be transferred to the surrogate mother?
Lordship, I have stated that that process was there and
Process we are not concerned with.
Lord.
Process, medical checkup and all that, that is
Lord.
not something which we are interested. First time the the pregnancy got terminated.
Lordship.
Right. Second time again with the donor gamete, the embryos were collected
Lordship.
and preserved to be transferred to the surrogate mother.
Lordship.
Where is that?
That paragraph 3, Lordship, may I kindly have a look at it?
Yes.
Paragraph 3. That the petitioners begs to state that on 21/12/2021, the petitioner and her husband went to meet the consulting Dr. Madhav Chandra Das. The semen of the petitioner number 2 was again collected by the doctor and initiated first phase of the procedure for surrogacy after failure of earlier attempts which resulted in failure.
Then what happened? After
Then also thereafter on 14/6/2022, the petitioners went to consult Dr. Madhav Chandra Das at Kolkata, who informed the petitioners that central government had enacted the Surrogacy Act 2021 with effect from 20.
Just in the process of collection,
Lordship.
it had not been, put to that IVF, not the IVF in the exact
Lord.
sense, for fertilization of the egg.
Lord.
So therefore, the process had not begun. It was in the process of. There was only semen collection.
Only what subject to your Lordship feels, Lordship.
No,
that,
if you are wrong on
Lord.
facts, please check us.
Lordship, that I understand, Lordship, but only thing is that if your Lordship.
No, that is a very clear distinction in. This Tapas Kumar Malik is. We would not consider it as a precedent.
Lord.
Tapas Kumar Malik, there's a short paragraph which says that it has continued, but then in Vijay Kumari and Arun and other cases,
Lord.
I think the process had begun.
Lordship.
The process had to be terminated, not the checking, not the collection, but eggs ready to be transferred. That also we have some doubts.
But that
That
applicant number.
It was said in Vijay Kumari and others, we can say that in view of this, but you'll have to make a specific statement whether the eggs have been cryopreserved for it to be transferred to the donor mother today,
No, probably. that-
or probably not today. Sorry, before the act came into operation.
Probably that is not the case. Because those were collected, but they could not proceed further. That
So then entire fresh exercise would be there. No?
what
That semen which was collected has been wasted.
Lord.
Correct.
Lord,
So
probably.
fresh exercise.
That intention was there, probably
Who doubts it?
15.8.
Who doubts it,
15.8,
sir?
Lordship, that intention.
Now, how do we get the justification of tinkering with this act and the rules, especially when the process is not continuing? Your checkup, your intentions, your going to the doctor advising you something. Earlier IVF failures, surrogacy failures, agreed. You're on a long journey, no doubt. But then this process where the semen has been fertilized,
That,
the ovum, whatever it is, that we have, the biology is long forgotten for us. So that is not there, no? Even if it had not been transferred to the surrogate mother, but it had been collected and preserved, cryopreserved prior to the act, we could consider.
That I admit that they have to take out initiate press procedure.
All right. So not on the facts, you question the act on its validity, virus. If you do that, we can hear you again. Otherwise, on facts, we have not made out with it. If you question the very decision, question the very rationale of this act, that rigid age requirement should not have been brought in, because it was not a normal process of conceiving. The doctors would not have allowed unless the surrogate mother or the male eggs were good. So therefore, age should not have been fixed. People at the age of 80 also can reproduce by this method. So if you question that, we will hear you. And we may caution you that that is difficult for us to interfere. That is a field which is unknown to law. That's purely medical input.
In fact, today I am having
one judgment we have delivered, one order, we'll not call it judgment, one order we have delivered today.
That I have heard. The only thing, Lordship, may I kindly have a 15.9, Lordship, for a moment, for my satisfaction. 15.9 of the judgment, Vijay Kumari.
Nine.
15.9. Obtaining various.
This only affirms, reinforces what we have been talking all this.
Lordship, only thing is that here your Lordship will find obtaining of various permission certificates from
You
appropriate authority.
read half of it. The other part also.
The other person also there. That in the present case of my predecessors, Lordship, they already appeared approached before this Honorable High Court when the act was not implemented in the state of Assam, Lordship.
Therefore, you were given the liberty to start that process in other
Yes,
state where the appropriate authority was there.
Yes, because they subsequently the central notified.
Unfortunate that because of this, it got delayed and now the new act came. But new act is
No, not the new act, Lordship. Here, Lordship, once this Honorable Court granted liberty to me, Lordship, I started that procedure. And in between, they again circulated one notification, Lordship, whereby they were debarred from using donor's egg. And now that has been recalled by the central. But during this process, Lordship, I am overaged. Not because of that act, Lordship. I was allowed, but subsequently they submitted one notice.
And that'll set a bad precedent. We'll be tinkering with law, no matter how much we may like to allow this to teach.
Because the entire delay occurred due to this proceedings. So that is
We are not getting persuaded.
That I leave.
That might risk the health of the mother.
In that case, may I pray one thing, Lordship? If may be directed to appear before the board, she will be medically examined. If otherwise she is medically fit, then your Lordship will consider, because that was also done in case of Supreme Court by the Honorable Apex Court.
Age bar is very rigid here. It is non-derogable.
Lord.
And how this direction means that please consider. Now, there could be, therefore, that is something questioning the wisdom of the legislature to put that age. It must be kept flexible, that you can argue while challenging the virus of the statute.
Your Lordship,
But then
those-
asking us to give a direction to the authority, to the medical team to assess your capability.
Because that direction was given in some of the cases by the Honorable Apex Court while hearing
Those are
this matter.
152 jurisdiction.
That I understand.
You understand everything. Lawyers understand more than the judges. Always. I'm not saying it in any sarky way.
No.
Because when a lawyer prepares a brief, he is prepared for all contingencies. Wrong questions, right questions, stupid questions from the bench. So he prepares himself on all fronts. You want us to give you another hearing? We are not happy closing it today on your face, considering the great desire of the couple to have a child. Question the virus to test it, but not facts we can't pass it. You want it to be closed down? No, we are not inclined.
Lordship take close in that observing that.
Lordship, writing number 25, it's a separate matter than 23 and 24. So that will be detached and heard separately.
We will hear all these petitions separately because it concerns motherhood and other things. So this is item number
23.
23. We have heard so and so. Judgment is written. Deal with such facts, huh?
Lordship, item 25, heard separately. Lordship.
Just a minute. Where is the positive ground? Look at these matters. We have passed an order in 23, no?
Yes.
Who appears in 24?
Lordship,
You're appearing in 24. You want to argue or you want to go the same way?
But what is the well within the age?
Then what is the problem?
That is the
Huh?
otherwise.
But what is the problem then? If wife is within age, then?
Lordship, in para 5 of the writ petition, Lordship, in item 24, is categorically been stated that the petitioner to failed on conceive through ICSA procedure, hence the medical authority started frozen eggs transfer procedure on 21/11/2022, 26/12/2022, 06/4/2023.
So that is post the act.
Yes, Lordship. After 25/1/2000.
Post the act, but
Age is there.
Lordship.
He is saying that he is
Yes.
well within the age. Then why did he petition?
But you know, if a husband is above the age group,
it has already been. Semen collected before.
no. There's only 22, Lordship.
No.
Lordship.
You have not stated anything about the semen, Your Lordship.
Hmm?
Regarding semen has not been stated in the petition.
Before rejected. 25? You want to argue separately?
Yes, sir.
Monday?
Lordship.
Monday, 25, we told you, 23. Tuesday.
Tuesday
16.
cannot be fixed, Lordship. Conducting council cannot be
When do you want it to be fixed? Next year?
Lordship, either on Monday or 1st of January.
First week of January.
So 23 is JV, then
23 is CAP.
24.
24 is CAP. Who appears in 26?
26
is difference. 23.
Okay, all right.
25.
The last set of where Mr. Gogoi is. We'll hear you through. Finish it off by 3 because there is a reference today. On.
Daily list for hearing, item 26 to 30.
Lord, I have furnished the compilation. Just.
Yes, we'll start hearing Mr. Gogoi only because Mr. Goswami and Mr. Sharma, you have completed your arguments.
My lord.
You can rebut whatever he said.
My lord.
Mr. Goswami, can you hear us?
Yes, Lordships. I'm sorry I'm unable to be there physically today.
No, no, it's all right. It's all right. Yes.
My lord, here, my lord, the bullet points I have given, my lord, in one volume. Yes, my lord.
One number 26 to 29. Yes.
26 to 29, my lord.
Yes.
Basically, my lord, my contention will be, my lord, in the bullet point is that, my lord, the entire selection was conducted by the two joint directors, my lord, that is Gwalpara and Dibrugarh, without, my lord, having the authority to even, my lord, initiate the selection process.
Yes.
That is the main limp of argument, my lord. Apart from then, that, my lord, the selection committee, my lord, was constituted without following the rules, my lord. Proper advertisement was not there, my lord. That apart, my lord, the rule 5 says, my lord, that, my lord, before, my lord, the conducting the selection, the nature of selection, my lord, whatever be the qualification and all, that will have to be prescribed by the government. Only thereafter he can conduct the selection. Nothing of that sort has happened, my lord, in the present case, my lord. And, my lord, he issued the appointment without having approval from the Director of Health Service.
But 15 years, this wisdom dawned upon you after 15 years.
My lord, this came, that part, my lord, I would like to bring, my lord, in the volume number 2, my lord, those documents, which is common in all the, my lord, 4 appeals. So I have brought it into 1 or 2 volumes, my lord, short volume.
Yes.
Volume number 2 starts from page 177.
Yes.
Lordship will see, my lord, oh, I'm sorry, my lord, it will be in volume number 1. Yes, I'm sorry, my lord. It will be from volume number 1.
Yes.
It starts from page 18, 1 And this has been admitted by the appellants also that, my lord, after this particular page 18, my lord, 2nd of March 2017.
Yes.
My lord, this pertains to, my lord, a selection of surveillance workers who were working. There, my lord, it was found that, my lord, they were illegal. And in the page 19, lordship will see, this is a
Just a minute. What is this page 18?
18, this is a communication to the Director of Health Services Assam, 2nd of March 2017 from the government. It says, my lord, that in the page 19 will be relevant for this particular batch of appeals, my lord. Further, you are requested to complete the screening process of the remaining surveillance workers and start similar process for other posts. That is grade 3, grade 4 posts. Also under your establishment so that their genuineness can be verified. A report in this connection may be submitted early. Now, my lord, in page 21, various committees were formed so that, my lord, the district authorities, they can, my lord, appear, including the joint director as well as the employees. All documents should be furnished before them and they will conduct the screening process. Page 21 onwards. District-wise, my lord, the committees were constituted. These are just communication, my lord, not to read it. Same, my lord, in page 25 again, my lord, on 17th of May 2017, regarding verification of genuineness of all grade 4 working in the districts. Page 26, my lord, it's part of that, my lord, document at page 25, 17th of May 2017. It says, my lord, just small para, I will read it. You are also requested to appear before the screening committee. This is to the joint directors, committee or depute SDM and HO headquarters of your district with all relevant records and with the respective dealing assistant and all incumbents grade 4 on the date and venue mentioned below, and also issue notice to all grade 4 to appear before the screening committee with all original documents with a set of photocopies. Failing which necessary action will be taken against them. The additional DSS, there is a / joint DSS of the district will be held responsible if proper records, documents are not furnished. So these was, my lord, various dates given. And this continued, my lord.
Now, Lordship may have a look at page 68. This is a order passed by this honorable court while the process were on. Now, my lord, when the district level, at the district level, my lord, it was verified. All my lord, grade 4 employees were directed to appear before a screening committee in the Directorate of Health Services. There, my lord, being agreed, my lord, the present appellants, some of the appellants, they approached the honorable court. Page 68, it starts, my lord, on 18/5/2018. Lordship will see, my lord, the relevant part at page 69, para 6. Here it was stated that the above stand taken by the state authorities should considerably assuage the apprehension of the petitioners. The petitioners are therefore directed to avail the opportunity to prove the bona fide of their appointment so that the authorities can reach an appropriate conclusion on their service status. As the proposed screening is scheduled to end on so-and-so, to ensure the learned additional general assures that it will be extended until 22/5/2018 to enable everyone to participate in the screening process. If anyone is found to be non-genuine amongst the serving persons, the authorities must, however, indicate the precise deficiencies and afford opportunity to the affected employees before any adverse action is taken. It is ordered accordingly. Thereafter, my lord, the screening process, my lord, was initiated, it proceeded, and so forth notices were issued without, my lord, giving that precise, my lord, deficiencies that were to be placed, my lord, as per the court's order. Again, they approached the honorable court. That lordship will find, my lord, page 141. Various petitions were clubbed together. And, my lord, the director.
Just 1 second.
Page
141.
Page 141.
Yes.
Here, my lord, in this batch of writ petition, in the next page 142, the director has filed the affidavit admitting that, my lord, the SOCOs were issued, my lord, without proper, my lord, mentioning the grounds, my lord. So we consider accordingly, my lord, we were given the liberty to issue
This petition was filed against the show cause notices issued.
Yes, madam.
Yes.
So we considered, my lord, the director considered that yes, there are some flaw in the SOCOs in the district level. So it will be, my lord, recalled and then press will be issued. Thus, I am showing, my lord, how opportunities were given, my lord, and we are very fair, my lord, to give them every opportunity. Same continued, my lord, in page 172, similar orders were passed on 21/1/2020 to, my lord, recall the termination orders and issue fresh orders. They were terminated without proper SOCOs. Then, my lord, page 172 is another order, my lord. Now, my lord, in 174, the director thereafter, my lord, considering, my lord, the various laws made by the joint directors at the district level, issued this letter to incorporate, my lord, certain, my lord, points in the SOCOs which were found.
Let us see this letter.
Yes, 174. To incorporate some points, my lord, like when was the advertisement issued, what is the select list, whether there was any approval and all. These were, my lord, directed to be there in the SOCOs so that, my lord, they can.
Tell us again the full form of SIU.
Staff Inspection Unit. It is a establishment of the finance department, my lord. So coming to the, my lord, next volume. Lordship, we will find at page 178, now, my lord, the SOCOs. Some deficiencies were indicated in everybody's, my lord, SOCO, as per the finding of the screening committee. Page 178. Just a simple copy I am giving, my lord, is there in the appeals otherwise of the. From 178, my lord, 2 copies I have given of two districts, one, my lord, Dibrugarh, my lord, Dibrugarh district. In page 180 is the removal orders, my lord.
Page 180.
180. It was directed to the joint directors to complete the process, my lord, immediately. And to, my lord, terminate those who were found to be, my lord, illegal or, my lord, not genuine. page 181 is a sample copy of
Now
the
read the
so-called.
first line.
With reference to the subject cited above, I am to inform you that the grade 4 staff whose appointments were found fake.
Fake.
Fake was the term, my lord, not properly worded, my lord, but because, my lord, all were, my lord, verified. Entire, my lord, batch of grade 4 employees.
That's right. But then fake is something different.
No, this is the term used, but finally, my lord, batch wise it is different, my lord. In Dibrugarh, my lord, Gwalpara and my lord, Dibrugarh, so far as this batch of appellants are concerned, there they found that yes, some, my lord, documents are there regarding advertisement, select list. But, my lord, in other districts, my lord, nothing is there, my lord. Not a single record that, my lord, even not a record to show that, my lord, appointments were actually issued. Those serial numbers, my lord.
Mr. Gogoi, have you not taken a Procrustean approach towards everybody? You understand what I mean by Procrustean?
Pardon me, my lord.
Procrustes. Procrustes was a bandit
My lord.
in Roman mythology. So what he used to do is that he would rob a person, make him sleep on a cot,
My lord.
and if the limbs, could not be accommodated on the bed, he would cut those parts of the limbs. So this is
No,
how
my lord,
he used
it was
to do.
not that harsh, my lord,
So
because
Procrustes, you have adopted the Procrustean approach of treating everybody alike.
no, just it was verified, my lord. And my lord, ultimately 412
Some were found to be without advertisement. There were some missing records in another district. So you chose to remove all of them.
my lord, they have not opposed again, my lord. They accepted the verdict of the learned single judge. Only, my lord,
That's
this
different. You are a mighty state. I mean, we are questioning you doesn't mean that we are with them, but,
but
these, are the
apparently, my
questions,
lord,
these are the questions which come to our mind.
my lord. In fact, my lord, in the repetitions, they, my lord, vehemently, my lord, made a submission that, my lord, there was advertisement, select list were there, call letters, but they could not furnish anything, neither there is there in a record.
I think most of the cases you say that there was no SIU clearance.
That part, yes, my lord, it is mandatorily otherwise required.
That's for withdrawal of pay.
Yes, lordship is correct, my lord. Without SIU approval, there would not be any.
And so
salary.
in many of the cases that was shown by Mr. Goswami and Mr. Sharma, it was only with respect to SIU. Would it render, I mean, the question before us is, would it render the entire, service to be fake on false letters, procured letters, everything bad?
No, not
Now,
only.
do you say that they are imposters? They could procure this letter from somebody, from some source which could not be identified, and they are working in the government. And then ultimately in 2005, they were regular. No, they were regularized when?
No, they were appointed regularly. That's their stand, my lord. Their appointment letters issued. Only in item 30, my lord, they were.
No, there was some regularization.
That item 30. That I will, my lord, argue separately, my lord. It will be separate limb of argument. Here, my lord, yes, they furnish, my lord, through RTI, some, my lord, advertisement as well as select list. I will place that, my lord. So now, my lord, in page 181, they reply.
Perhaps this exercise, though the courts did not interfere with this, but this was with you. You are the custodian of the records. Why to ask from the employees, and that also in
No,
huge
without
number?
giving that opportunity, my lord, again, we gave them ample opportunity to establish that. Otherwise, we were sure that, my lord, they are not genuine.
Have you
But that-
disputed this advertisement and selection and all that?
My lord,
Have you disputed that these two joint directors never?
yes, that we have disputed. That we have disputed, but I placed that. So, my lord, 181, just placing the documents in the entire bunch, I have compiled to these two.
Very good. Yes.
Page 181, my lord, this is a so-called stereotype reply. All have furnished, my lord. Probably one has drafted and everybody has signed, my lord. Same thing.
And,
He has drafted.
and same show cause.
Same. Yes.
The show cause is same. The answer is same.
Yes, my lord. Now, my lord, now, my lord, one plea has been taken by the appellant side. That, my lord, page 188, it is in respect of Dibrugarh district. They say that, my lord, after the selection, the select list was forwarded to the Director of Health Services.
Yes, this
for
was,
their
one of
notice.
the, this was one of the arguments.
Yes, page 188. Lordship, may kindly see the, my lord, may I read the, my lord, small 2 lines, my lord? With reference to the subject cited above, I have the honor to inform you that the selection board, Lordship will kindly mark this, my lord, selection board constituted for selected candidate for recruitment to the post of so-and-so on so-and-so. My lord, from the plain language, my lord, reading, it seems that, my lord, the selection committee was constituted. That was, my lord, intimated to the director, not the select list. May I read it again, my lord? With reference to the subject cited above,
yes,
I have the honor to inform you that the selection board constituted for selected candidates for recruitment to the post of grade 4 on so and so. So, my lord,
No, read the second line also.
Enclosed
You
here is
can
the
completely
list.
avoid reading that.
Yes,
Enclosed here
enclose
is
the
the
list
list of for favor
and necessary action.
necessary action. What does this list mean?
Select that constituted committee, maybe there were 2-3 committees, lots of candidates may be there. Now, along with
This list refers to the
Yes.
because this is
according to the appellants, this was the list that
no,
was
no.
forwarded.
What about you? Forget about
We have not received any such list, and if at all had it been there, there would have been some approval.
this is joint director of health services.
Only in
The
respect
director
of Dibrugarh, Gwalpara, there is nothing to nothing.
Gwalpara
No
is all right.
document. Yes.
But you club Gwalpara with Dibrugarh.
No, my lord. Similar set of advertisement election, something are there, my lord. Not in other cases, no such advertisement or selection.
One batch, one batch of law students. Some degrees are found to be fake. Would you say that all from that batch would go?
No, that is not the case here, my lord. It's not the case that, my lord, out of 70, my lord, persons selected, 20 has been found to be, my lord, illegal. So instead of cancelling the entire selection, 20 should be cancelled. Here, my lord, in my lord, Gwalpara and Dibrugarh, we have, my lord, cancelled entire batch. And, my lord, the main reason I have stated, my lord, that the joint director conducted the entire selection, flouting the rules, my lord, without any approval, even knowledge of the authorities.
But what did director do when the everything was given to him?
My lord, this has never been received. My lord, Lordship will see we have made a categorical stand.
I mean, what is there to believe your statement that the director never received it?
No, my lord.
Stated in that
Yes, my lord, from my lord 2002 till 2006, my lord, there was a complete ban. Even, my lord, the order of ban says that not only SLAC, the state level empowered committees approval, even the departmental minister, if he has approved it, then also no appointment should be made. In between, this was done. During the ban period, there is there in
Where is that ban?
Yes, my lord.
Letter?
My lord.
Where is the ban?
Yes, yes. Lordship will find that page 222. 222. It says, my lord, I am directed to request you not to issue any kind of appointment until further orders, even in cases against which permission of state level empowered committee, it's like SIU, my lord, and approval of the Honorable Minister, Health and Family Welfare has been obtained until further communication. After this document, my lord, this was duly considered by learned single judge, page 228, my lord. This was the first communication after the ban that is available as on there in the director's record to show that, my lord, in 2006, government directed the directorate to conduct a, my lord, selection for the first time after this long period of 4 years. 19 January 2006. It is from the under
226.
228. 228.
That is so funny there.
Under Secretary to Government of Assam, Health and Family Welfare, to the Director of Health Service and Director of Health Services Family Welfare. I am directed to say that the Cabinet in its meeting held on so decided to launch special recruitment drive for filling up the backlog vacancies of so and physically handicapped persons. Accordingly, we were instructed to take all necessary steps in this regard for filling up such vacancies. The matter has been badly delayed. We are therefore requested to fill up the vacancies as decided by the Cabinet urgently and issue appointment letters. Lordship will see, my lord, this part and to issue appointment letters to the deserving candidates. So it is the director who is the appointing authority. Against the selection made through selection committees.
So therefore, ban was partially lifted, no?
Yes, yes. In 2016, thereafter.
So therefore, this.
Here, my lord, it was in end of, my lord, 2004, and, my lord, by February or say March till July, their appointment letters issued by the joint director. Prior to that, and Lordship will see, my lord, just for a moment.
No, whatever it was, the ban was lifted. No, not only backlog vacancy for SPST and physically handicapped.
And, my lord, regarding SIU part 2.
The backlog is common department.
Just, my lord, page 231 again, my lord. This is the communication of the Joint Secretary to Government of Assam Finance Budget Department, Lordship will see. how, my lord, things are done prior to appointment and even after appointment. Here, my lord, the Joint Secretary Finance Budget has, my lord, instructed the Treasury that I am directed to say that the following 76 numbers of posts under Health and Family Welfare A Department are filled up as per approval communication of finance SIU so and so. So it was intimated and accordingly these appointees will get the salary. This is the process, my lord. But in the present case, my lord, neither SLEC nor SIU approval was there.
But how come they were being paid?
My lord, that's the scam, my lord. Now it has been detected and accordingly we had to take our, my lord, hearts. Of course it is hearts, my lord, but we'll have to, my lord, we have to act upon. Because illegally it cannot be allowed to be, my lord, continued. Just, my lord, to show, my lord, that how this, my lord, approvals are given. Lordship will see page 269 for a moment, my lord. This is a part of the affidavit that we have filed in the appeal. Just for instance, my lord, on 24th of January 2006.
269.
This, my lord, that special drive for ST and SC backlog, I have shown that, my lord. This was the drive initiated. It is the director who has issued the appointment letters. Page 269, 24th of January 2006. The subject to discharge without notice and without assigning any reasons thereof, and in anticipation of receipt of satisfactory PVR, the following persons are appointed.
That's true. So this was
So that, my lord, this is not a joint director. The appointing authority is the director. That's what I want
There's
to
no
point.
difficulty. Appointing authority is the director.
Yes.
But their argument is that this is all right. It's because there was no appointment of SC, ST, handicapped persons that remained vacant.
No, no, that my lord, may I proceed further? Just page 271, part of the select list. One, my lord, last line. The appointment order is issued with the approval of the government. So, my lord, everywhere without, my lord, keeping the, my lord, government in dark, the subordinate authorities, including the director, they never issue appointment letter. They'll have to, my lord, move the, my lord, government. Government will move the finance for SIU or SLEC, whatever is there. It's the process, my lord. Then, my lord, again, my lord, Lordship will see page 272. In 2008, Dibrugarh district, it is the director has issued the appointment letter, instructed the joint director to give the appointment. I am just placing, my lord, how appointment letters are issued. Then again, my lord, page 273, finance has given the SIU approval and instructed the treasury officer to release the salary in 2008. Now, Lordship will see how page 278, how it is delegated, my lord. Lordship will see the delegation part.
278.
Yes, just, my lord, one instant. 19th of February 2009, it is the government has delegated the power to the joint director to conduct the selection. So some authority will have to be there. In continuation of department letter so and so, I am directed to request you to take immediate necessary steps for recruitment of 9 members of so and so. So he can conduct thereafter. But here nothing of this sort was there. Even, my lord, in cases where, my lord, joint director is conducted, he used to furnish the list to the director for approval, and director used to approve
And
it.
this joint, all the appointments have been made by one set of joint directors.
In the present case, 2 batches, my lord. Yes, my lord. One selection, one, my lord.
Have
same
you
set of-
proceeded against the joint director?
My lord, 2005, my lord, today.
So post-retirement, if he's alive, all his pension has to be forfeited. He has created problems.
Lord, that of course, my lord, will.
Have you done that?
That, my lord, have to, my lord.
You have chosen a soft target.
No, my lord. In fact, my lord, in the Learned Single Judge's order, there is already a direction.
Did you question the minister then?
My lord, that part, minister's part is not there, my lord. There is no such finding that, my lord.
So
it is
even
at the
director,
behest-
because- just a minute. So the communication was made to the director. Who was the director that time who agreed? He did not bring it to the notice of the government that, look here, they are only intimating to me the appointments. I never delegated this power to them.
Nothing of that sort, my lord. No, it was never forwarded to us. Just, my lord, page 279. 279 will prove, my lord.
And you have made that statement in your counter affidavit that it was never the director was never in receipt of the same.
My lord, that part in the additional affidavit, we have stated that during the ban period, there is no such selection, nothing was
Forget
there.
about ban period, post-ban period. Now, after the appointments, we are only testing it from all angles.
Fine.
Now this joint director, they acted on their own. So far, bad.
My lord.
But they communicated it to the director.
There's
You say that the director did not receive it, but it was not possible without the director's, approval that they will be getting salary.
My lord, in the entire state, as I say, my lord, 412 has been terminated, including the appellant's hearing, few of the appellant's hearing. My lord, they were all were getting salary. They never approached the honorable court for salary, and it was subsequently honored that, my lord, they are illegal. They were getting, my lord. That's the scam, my lord. That's why, my lord, we had to take a stand. That, my lord, we will not allow.
When you use the word scam, you have to be very careful.
No, I'm scam, but that was the illegality going on.
Scam means you are responsible. The state is responsible.
Of course, it is by the officials, not by maybe all the officials, but a set of officials, my
It
lord.
is not by the appointment letter has not been given by middlemen as these people do today. Well, give me 5 lakhs, I'll give you appointment letter. There is no advertisement, nothing of the kind. Is it something of that kind?
My lord, so far as Gwalpara and Dibrugarh is concerned, it is the joint directors appointment letters they have annexed, my lord. In other cases, my lord, there are appointment letters issued by the director. But, my lord, there is no such, my lord, actual, my lord, such letter, and the issue numbers are there, my lord. It's not available.
What I was communicating to you was that this could be a big scam during 2002 to 2006, 2005. There could be a scam. But when this direction was being given in 2006 with respect to filling up of backlog of SC, ST and handicap, then also there was no question with respect to those. See, why that employment drive, recruitment drive was carried out? Because there was backlog of vacancy only for particular categories.
No, my lord, in general, my lord, in one advertisement.
You showed that letter to
No, that's a separate, my lord. That's after 2006, there was a direction from the government. Then
don't take it that way. See, the entire process from 2002 to 2005, the places which were vacant, it was filled up.
Yes.
Only those places could not be filled up, which had to be filled up from the category of SC, ST and handicap. And therefore, there was a limited window that, well, these have not been filled up. This is a backlog. Please carry on the recruitment drive. It's not that.
Yes, probably, my lord. Yes, going.
So in that case, you were not unaware of the situation.
No, my lord. Regarding the illegal appointment and the selection process, my lord, this has come to light only, my lord, in this particular
How
screening
do you
test.
want us to read that this ban was relaxed only for SC, ST? I don't think.
No. In generally, my lord, after, my lord, that 2002 letter, which is there in our record, we have only found.
You dare not take that plea. For that, you will be on a worse footing then.
No, it's the government who is there. Thereafter instructed us to go for that backlog, filling up the backlog.
So backlog because there was no appointment. Rest of the
No,
appointments.
thereafter, no, I have shown the appointment letters. Subsequently, there were various appointments. 2007, 8, 9.
That's all right. So they would be perfectly entitled to argue that before this, the recruitment drive was there and people were taken in.
My lord, regarding the drive part, that's why in the very first beginning I said, my lord, a recruitment drive, if at all has been, my lord,
It did not have the
initiated,
sanction of the government.
that's my lord. And in fact, I will place one judgment which the Honorable Supreme Court says that will be a nullity.
There can be no because there could be a nullity is all right, but there are other judgments also, no?
My lord, that supports me. Of course, I will rely upon that. I am banking upon that, in fact, my lord,
Yes.
that whole case.
But we have to take a consistent view with the Supreme Court.
My-
We can't go in derogation of what the principle said.
But my lord, so far as the present case is concerned,
You are
that's
absolutely
covered.
right.
Squarely
If, there
covered,
is,
my lord.
if it is found that there was no examination, nothing of the kind, sheet of paper was given to somebody, please join, and then it was regularized, I think all of them need to go back to their homes. But here is a case where, as we understand, this process, this all kick-started when there were some surveillance workers about whom you had doubts.
No, my lord, they were found to be illegal, my lord. In fact, in the case of surveillance worker, the entire office, my lord, they caught, my lord, it was burned down. And only their documents, those illegal appointees, they were burned. All legal appointees, they were coming up with the appointment letter. They say that we have given the original letter to the office. It has got, my lord, or totally, my lord, destroyed in the fire. Otherwise, legal, my lord, whatever records we have in the directorate, they have got the appointment letters. Only those, my lord, who there is no record of any selection, they say that we have not even kept a photocopy of the appointment letter. We have given it to the director.
That is.
So thereafter, my lord, this entire thing came up. And that, my lord, termination was upheld by the division bench also, my lord. There's another bench for surveillance doctor. It was upheld.
No, there is no surveillance.
No, here, no, it's only grade 4, my lord, apart from surveillance doctor.
And what has
My lord,
happened?
pace,
Surveillance workers also had continued in service for 15 years.
no, it's a short period, but my lord, ultimately they were terminated, upheld by the, my lord, division bench also.
That's all right. Short period. This is
No, not short period, my lord, they were there. I can place the
There-
there actually.
there. The main argument, core argument is the passage of time. And you were aware of their existence, not that you were not aware.
Aware, but we are not aware that, my lord, they are illegally continuing. Because they were getting the salary, my lord. Annual budgets were there. Because without that, they could not have been, my lord, paid the salary. My lord, page 279, my lord, just to show, my lord, where approval is necessary. Page 279, 21st of February 2009. It's from the director to the joint director, Dibrugarh. Lordship will see the Dibrugarh district here. In 2009, it says, with reference to your letter cited above, I am to approve the names of the following candidates. Selection was conducted by the joint director. He has forwarded the list. It was approved.
This is the proper process.
This is the process, my lord. This is absent in the, my lord. Even other instances are there. We have an expert. And in page 281 is the Gwalpara district. 2010, my lord. Page 281, 279 is Dibrugarh. 281 is Gwalpara. For instance, my lord, we have just placed it. Here again, my lord, with reference to your letter, I am to approve the names of the following candidates. So approvals are there. And lordship will see in both the documents, the approval of the government, my lord, approval number is also mentioned. So this is the procedure, my lord. Otherwise, there will be, my lord, chaos. In fact, my lord, one judgment I brought, but the too lengthy spoil system, my lord, has been, my lord, described there.
We are aware of
Regarding, my lord, grade 4
Honorable
employees.
Justice Markande Kadzu.
Lordship, I am obliged. Regarding grade 4 employee, huge market has come up that all these were discussed, my lord. In fact, my lord, one
Class 4 is no spoil system. A spoil system in US was on a higher post.
yes, yes. That ultimately, my lord, one, my lord, more judgments are there to show, my lord, regarding judicial sympathy also with due respect, I am saying. In case of illegal appointment.
Misplaced sympathy is absolutely.
That also I will like to deny.
That does not get the sanction of law.
Mine.
We're right. You're right. No misplaced sympathy. Why? Sympathy for what?
Mine. That I.
Because if they vacate the place, it would be sympathizing.
And Article
people who are
14 and
interested. Now, we are questioning this. We are overlooking this not on grounds of sympathy.
Mine.
Period of service that they have spent with regular salary is not with sympathy.
Mine.
That's not
No,
sympathetic
that's why I
consideration.
said with my lord,
That's a
yes,
consideration. That's a consideration based on long tenure.
Lordship.
That's a very important aspect of the matter.
And on that aspect also, my lord, including Uma Devi and all various judgments, I have one or two I have. The long tenure of service will not enter, yes, for regulation and all. There cannot be a ground that if it is a nullity, my lord, it goes, my lord. There cannot be any.
That basic principle of law has not been diluted up till now. That is correct. These instances are some kind of TP and malaria appointments in the state of Bihar when there was one director called Mr. Khan. And there were about 2,000 appointments and all were set aside. Litigation continues even till today. Because in batches, people went to Supreme Court, came back with remand orders, and then again the administrative authorities looked at it. All these cases that you see, Satwan Prasad Singh, Umesh Prasad Singh, they all originate from the state of Bihar.
Lordship. So, my lord, these are the documents which have been relied upon. These are part of the appeal memo I have placed in these 2 volumes, my lord. And my lord, my bullet points, my lord, I have already stated. I have just described in short paragraphs.
Please repeat it.
It's that volume, my lord, where the read appeal numbers are there, my lord. The read appeal numbers are there, my lord. My lord, first para, that pursuant to a selection instituted by the then Joint Director of Health Services, Gwalpara and Dibrugarh, the read appellants to the above 4 read appeals were appointed by the Joint. My lord, first para, bullet point number 1, my lord, Roman 1. My lord, where, my lord, the case numbers are there, it starts with the case number, yes, that.
ये वाला है कि ये लोग अब कहते हैं, but they don't give any advertisement. They have not placed any advertisement on
My lord,
record.
Yes, yes, advertisements are there. My lord, it's there in the first volume.
Irregular, no? Not illegal.
Volume 130. My lord, it is there, just I would place that also, my lord. Page 10 is the advertisement of Dibrugarh. And my lord, page 14 is the, my lord.
That's your record or they have brought it?
No, from the appeal memo, I have.
No, but that is your record or they have brought it on record?
They have brought it on record by
Through RTI.
subsequently during the, my lord, initial cessation of the, my lord, that read petitions by of an additional affidavit. Through RTI. But my lord, in the advertisement also, my lord, in one advertisement of my lord, Walpara, they saw that some newspaper it was published.
Where is that advertisement?
Yes, page 15.
In
the
the
volume
first
number
volume.
1, my lord. Page 15, 1-5.
This was in which state daily?
My lord, it was in one, my lord, Khobor. 3rd of January 2005. The, my lord, translated, a type copy is at page 14. Here, my lord, the post, it was 70 posts of grade 4.
Applicant must have read a plan the appraised letter. It is needed to reply along with the part of the gap that might join that.
And of Dibrugarh district at page 10. Now. But there is nothing to show that it was published. And my lord, the advertisement, the posts are also not mentioned. This is otherwise required, my lord, to be indicated in the advertisement that
correct.
It is here. Otherwise, it goes on, my lord.
Correct.
That's one of the.
Correct.
After, my lord, interference of the Honorable Supreme
Only
Court,
with the
my lord, now-
intervention, only with the intervention of Supreme Court
Yes,
has
my lord.
become a
It has
mandatory
become a procedure
requirement
that
that
we'll have to.
this is for ensuring fairness.
Yes.
Otherwise, anybody can get
Yes,
in.
my lord. In any, the list continues, my lord, for years after.
So this was not in 2005.
My lord,
This was the regular thing. You know, even High Court appointments.
No, my lord.
Applications are invited.
Yes.
In those days, 2005, applications are invited for appointment. They would not disclose because the posts, the vacancy remained fluctuating.
Yes.
Whether carry over, no carry over. And once you specify, you can't add, you can't lessen.
My lord.
So those were the reasons. You see, we are looking at it from a very strict scrutiny point of view for the reason that they are, class 4 employees, and the state has chosen to throw them out. It's only for this that we are seeing it this way. Had they been class 1, class 2, one flaw, we would have closed the file.
I understand. But my lord,
This is no misplaced sympathy. This is the mandate of the Constitution.
But well, now, my lord, factually, these are the issues. My lord, may I place the judgment now, my lord?
Yes.
Probably, yes. It's in the, my lord, the same volume, my lord, where the numbers are there, my lord. Yes, I have flag marked the volume judgments, my lord. One company, yeah. Lordship will see flag mark A. This is the judgment Raghuvar Pal Singh's case, my lord, 2018-15 SCC 463. My lord, may I read para 1, my lord, at page 13, starting of the judgment. Page 13. Yeah. The central question posed in this appeal are: one, whether the appointment of the respondents to the post of veterinary compounder made by the director in charge at the relevant point of time without approval of the competent authority was a nullity or a mere irregularity which could be glossed over by the department to avert disruption of service. So issue number one, my lord, squarely covers, my lord, so far our issue is concerned. That is my humble submission, my lord. Now they went
Just 1 second. Now, this was within 1 year, the service was terminated. Within 1 year. The appointments came in 1999. The termination order is of 2000.
My judgment for you. This is a blue. Not it. It's not it. What do you think? But he's a government. He is not a middle sum local.
Yes.
Now, my lord, the tribunal's my lord, order, page 17, para 10, my lord. Tribunal held that, my lord, the tribunal then averted to the legal position that any appointment made devours the statutory rules has no validity, and that those who come by the back door have to return to and so. So this was the.
Those who come by the back door have to return through the front door.
Back door.
Have to return through the front door, no?
No, maybe by the same back door. That
Maybe excuse for 5 minutes, my lord.
By the same back door is.
May I maybe excuse for 5 minutes, my lord.
Yes, yes, please.
In fact, my lord, in this case, my lord, the reason for this statement is that even, my lord, the honorable court held that the so-called notice or necessary justice is not necessary, my lord, once it is found that the appointments are a nullity. My lord, then I would rely upon, my lord, paragraph 20, my lord.
Perhaps you should have passed this order in 2007. You would not have even questioned you.
But my lord, it was admittedly not in our knowledge.
But it illegal act cannot be perpetuated. That argument we are keeping it in mind. Yes. Then next just
now para 20, my lord, these are various discussion. Thereafter para 20, some observation has been made by the honorable Supreme
in the
Court.
same judgment.
Same judgment, page 21, continuation, paragraph 20. Page 21 is the para 20. For taking this contention forward, we may assume for the time being that the director in charge so-and-so agriculture officer had the authority to issue a letter of appointment. Nevertheless, he could do so only upon obtaining prior written approval of the competent authority. No case has been made out in the original application that due approval was granted by the competent authority before issuing of the letter of appointment.
Yes, we have seen that.
My lord, then my lord 25 and 26, my lord, page 24, para 25, 26. Same has been reiterated by the Honorable Supreme Court that it will have the letter of appointment in so and so termination of the appellant therein, albeit without notice, was not interfered with by the court, as admittedly the same was not approved by the competent authority. The underlying principle will apply proprio vigore to the present case, as a letter of appointment has been issued by an officer who has no authority to do so, and also because it was issued without waiting for the approval of the competent authority. And same, my lord, in the present case, if at all, say, my lord, that 2002 letter was communicated to the director.
The High Court like us, para 27. You are reading para 26, but we are referring to para 27. Like we are asking this question that what has happened, what action has been taken against the director and joint director. The same question was asked by the High Court. The Supreme Court says that to which that is not the consideration. That ought not to be the consideration. That's right. We are observing now in your favor. The other reason which has weighed with the High Court, in our opinion, will be of no weight to the fact situation. To wit, the fact that the subject office order does not attribute any motive to the director can be no basis to invalidate the same. Can be no basis to not to invalidate the same. In our opinion, the office order records just and tangible reasons as to why appointment of the respondent is illegal. All right.
And my lord, just my lord, para 28, place it on C. C and between C and D, in the right hand side, my lord, in the present case, the letter of appointment should be issued by the designated director and only after grant of prior approval from the competent authority. This is a repeat, my lord. Without such approval, the then director inserts in no case could have rushed through the process of issuing the letter of appointment and action which was without authority of law and nullity. In the case of Dibrugarh, my lord, even if we say that, my lord, a letter was communicated along with the
Budgetary provision is made for their salary.
my lord, that comes from the district, goes to the director, and my lord, whoever is there regularly appointed. And it is, my lord, placed before the budget, before the 31st of March. And if approved, my lord, the entire for the year, my lord, that allocation is there. And it never, my lord, it remained unnoticed, my lord. Only had this, my lord, screening test, my lord, not initiated, those they would have continued till their retirement.
Yes, next case.
My lord. Next will be, my lord, page 27. A. Umarani versus Registered Cooperative Societies and others. Page 27. My lord, paragraph 6.
No, legal.
Page 34. Here, my lord, I will rely upon para 38, 39, 40. It will be in page number, my lord, 40. Just, my lord, on regarding regulation part. 38, Lordship will see page 40, para 38. The provision of the Act and the rules framed thereunder reflects the legislative recruitment policy. The said provisions are thus mandatory in nature. Page 40, my lord, running page 40. Para 38. The provisions of the Act and the rules framed thereunder reflect the legislative recruitment policy.
Which page you said?
38, man. The provisions of the Act and the rules framed thereunder reflect the legislative recruitment policy. The said provisions are thus mandatory in nature. Regularization, in our considered opinion, is not and cannot be the mode of recruitment by any state.
Mr. Gogoi, this is 2004 judgment. We are in 2024-25. You read those judgments.
Yeah.
There are 3 judgments which have changed the entire scenario. Jaggo, Dharam Singh and Sripal.
Yeah.
These 3 judgments.
But, my lord, there, my lord, in considering the individual, my lord, facts of that particular petitioner or appellant, my lord, that order was passed, but that cannot be, my lord,
cannot be applied
in
across
them,
the board.
my lord. Just, my lord, my
Next.
submission will be.
Next.
Next, my lord.
This is again, in this case, only Upendra Narayan Singh, there is a discussion about spoil system.
Yeah. Yes, ma'am. No, my lord, 2 more, my lord, of this particular judgment, page 46, 69 and 70 para. That, my lord, sympathy part, my lord, just I am referring, I'm not.
Don't be so apologetic in making arguments. You can make arguments, it is for us to accept or not to accept. Mr. Gogoi, you do not fully know this bench. This bench asks questions and is ready to accept questions.
I'm applied.
There is no difficulty. You can make such submissions, provided you don't exceed the jurisdiction. Yes,
Page 46, my lord, continuation of Umar Anis case. Page para 69.
Para 69.
In Terry or State Private Limited versus Union Territory of Chandigarh, it is stated, para 36, it has been quoted. We have no doubt in our mind that sympathy and sentiment by itself cannot be a ground for passing an order in relation thereto. The appellants miserably fail to establish a legal right. It is further treated that
there are even stronger expressions in judgment about misplaced sympathy. This is very soft by Justice S.B. Sinha.
Again in 70 also, my lord, one more judgment has been quoted. We repeatedly asked the learned counsel for the appellants on what basis or foundation in law the appellants made their claim for regularization and under what rules their recruitment was made so as to govern their service condition. they were not in a position to answer except saying that the appellants have been working for quite some time. In various schools started pursuant to resolutions passed by Zilla Parishad in view of the
All right,
government.
you've seen that. Now,
That my lord, long continuation part also it is covers, my lord.
Upendra
Upendra Pal Singh, my lord, I would rely upon para 51, 65 and 66, my lord. Here, my lord, there was a ban period, my lord. Page 56, my lord, the factual part, para 2. After taking cognizance of the fact large number of ad hoc appointments were being made in different departments without complying with the relevant rules and procedures, the government of Bihar by its circular number so and so, which was followed by another circular number so and so, imposed a ban on such appointment. Notwithstanding this, an ad hoc appointments.
And there the director of TB
Yes.
Institute, he never came out of jail.
But that relevant para.
Rahman somebody.
Yes. My lord, para 33 speaks about, my lord, it starts, my lord, the spoil system, a bird's eye view.
That is,
That on the, my lord, 51, I rely on.
no, spoil system.
No, I'm not on just, I'm just pointing out. Page 71, my lord, para 51.
No, spoil system should not, the word should not give you a feeling that spoils is the spoiled nature of thing. No, no, no.
My lord.
It's distribution of largesse.
Yes. That's it.
So that is with respect. A spoil system continues in America.
Yes.
In US, most of the appointees are through a spoil system.
My. Then para, my lord, 65 and 66. It will be in page 85, my lord. My lord, here, my lord, article 14 and 16 is there regarding regularization part, my lord, not for this batch, my lord, that will not cover because it will be, my lord, under for the item number 30, where, my lord, there was an advertisement working on ad hoc basis, subsequently regularized in 30, my lord. Now, my lord, next page 91, my lord, here I'm relying upon few of the paras, my lord. It's National Fertilizer Limited and others versus Tomveer Singh. Reported in 2006 5 SCC 493. Here, my lord, there was a complete ban, my lord. Para 1 starts at page 93. The appellant is a government company. It is a public sector undertaking. It is stayed within the meaning of Article 12 of the Constitution. A policy decision was taken by the appellant not to make any further recruitment in the marketing division in any category of post stating. So this was quoted. Para 2 says the respondents have been appointed despite such ban. Before such appointment, the employment exchange was not initiated, intimated about the vacancy in terms of the provision of the employment. Admittedly, no advertisement was issued. Here, my lord, of course, in our case, my lord, advertisement was there. But during ban period, my lord, this selection was made.
That selection was made only on the basis of application made by those persons.
Now, para 16 and 17, I rely, my lord, 17. May I read
Just
those?
indicate the paragraph. We have,
Yes, 16 and 17, ma'am.
we have to give some time to them to rebut, no?
No, my lord, so far as their judgments, my lord, they have relied upon two judgments, my lord. I would like to counter that also. And ML Kesri also, I would like to point out why I'm saying is, my lord, the argument advanced from my senior counsel, Mr. Goswami, was that, my lord, if at all, my lord, their cases are to be considered is to be as an irregular appointment, not at all as an illegal appointment. And for that, my lord, ML Kesri was referred to, where, my lord, that irregularity and irregular appointment and illegal appointment was described. Following para 53 of Umadevi. There, my lord, yes, my lord, the entire para 53 of Umadevi contains that, so far as the casual workers are concerned, my lord.
Yes.
My lord, so far as the casual workers are concerned, contractual casual workers, Umadevi has held that, my lord, there cannot be such regularization, my lord, violating Article 14 and 16. But as a one-time measure, as an exception in para 53, it has been stated that those employees who are working on a permanent post and have got the requisite qualification and have continued for more than 10 years till the date of passing of the Umadevi judgment, they can be regularized and they can be held to be irregular appointment, even though there is no selection. That was a category of irregular appointment, and that has been described in ML case 3. That particular irregular my lord, term cannot be applied to this particular case, because here is a case where there was a, apparently it seems my lord, from the record that they have placed, that some selection was held, though my lord, violating the rules without any authority, and they are not ad hoc appointees. So that irregular term, my lord, cannot be applied in the present case.
They are better than irregular.
More, my lord, worse than irregular. What I am saying is they are illegal, my lord, because the selection is illegal. Ad hoc appointees regularized as a one-time measure, my lord, under para 53. Even our state has adopted that policy.
Yes, yes, we have read that judgment ML case number of times.
Yes, my lord.
Yes.
And my lord, Mamta Mohanty's case also, I just one, my lord, in fact, my lord, page 137. I rely upon para 36 and 37. Thirty-six says, my lord, page it's at page 153. Mamta Mohanty's case. Therefore, it is a settled legal position that no person can be appointed even on a temporary ad hoc basis without inviting applications from all eligible candidates, even an appointment is made by merely inviting names from the employment exchange to ensure on the court, etc. Same will meet the requirement of Article 14 and 16 of the Constitution, such a course violates to ensure. Now, my lord, 37 says, my lord, order bad in inception. My lord, the order of appointment issued by the joint director without any authority in the very inception, my lord, it goes, my lord, it is bad in law. So they cannot, my lord, claim for any benefit of that particular appointment, my lord. Page 37. Order bad in inception. My lord. It says, my lord, it is a settled legal proposition that if an order is bad in inception, it does not get sanctified at a later stage. Just because they have continued, my lord, for a certain period, my lord, without being detected, that will not, my lord, entail any benefit, my lord, or right or legal right to them to claim that, my lord, they should be allowed to continue till their retirement.
Suppose they had not, this was not noticed. It went unnoticed till the time the superannuated. You found it only after that. Would you recover the salary?
My lord, that, of course,
We're just extending the argument.
my lord, that will be, my lord, the wisdom of the government to take a call if at all such a situation arises. My lord.
You can't.
Of course, my lord, I
Last
understand. I
one.
cannot directly make that submission, but yes, we cannot. Of course, this honorable court will interfere if at all such is taken. Because we have expected their service, my lord, then thereafter gone. Even in this case also, we have not gone for, my lord, we refund or we do. That's I'm saying, my lord, yes, that we cannot do. Now, my lord, the judgments that were relied upon by the petitioner. No.
Mr. Gogoi, how long will you take again?
My lord, I will
You have to raise for the.
Yes. My lord, so far as item 30 also, I would like to make some submission because that is a separate issue. They were ad hoc casual employees, my lord, regularized.
Yes, when do you?
My lord. Monday. Tuesday. My lord, in that case, Monday or Tuesday, any day, my lord, it will take hardly a few minutes, my lord. I will have to counter their argument also, my lord, on the legal side, my lord. Their judgments, I would like to counter from their compilation. My lord.
One day we have how much? The entire week we have more than 40 matters.
I leave it with your.
And otherwise, this is as of now.
Mine.
We will place it in the first week of January.
Mine.
So that before the court closes again for Pihu, you finish your argument.
No, my lord, I will not take much. My lord, I will go.
Both sides, all are.
Both sides, my lord, yes.
Yes, Mr. Sharma? First. Let it be on the
Can be on
first.
this side of the vacation.
This side of the vacation, that's what we were checking up with our calendar. It's all every day. Because of the last week, urgent matters are coming. No, we will not, even if we place it, we will not be able to hear you. Today we would have finished, but for the reference. So we keep it on the reopening day. Anybody having any inconvenience in approaching this court, you can come, you can appear online. Arguments to continue? Re-notify first day. Sequence में प्रजा को बताइए करते हैं इनको भी हमको
Lordships, it's typical of
obliged.